Hello, everybody. Happy New Year! Billy decided that he needed to be a part of this. Yes, he really did. He's been needing to be a part of everything. Much to the detriment of my editing. And I'm not going to lie. You know, he's cuddled up on my arms right here on my desk, and I kind of dozed off in his fluff. I did. Yep. Head down, just listening to him purr, and I was out. So I missed East Coast. Happy New Year, East Coast. I am so sorry I missed you. And I know it's been New Year's in Australia and all of our friends overseas. So thank you all for being a part of 2024. It was wild. But we had such a great time. Oh, goodness, did we ever. Hello, Nana Laura. Hello, Spider-Man. Pork rinds, Pepsi, and strawberry ice cream. Thank you so much. I love you. Hello, Joey Bag of Donuts. Oh, yes, we are. He's a bit of a hothead, but sometimes warrantedly so. Yeah, I do love this guy too. Hello, Patrick B. I've missed you. Good to see you here. Oh, I don't own a 2025 Mercedes license plate Bolt, but I've got a neighbor that's got almost everything in his garage. There might be one there. Hello, C-Rex, my sweet love. You guys are so amazing. I can't believe you're choosing to spend this time with me rather than, be out tearing up the town. Yeah, I don't tear up the town well either. Oh, hello, Fozzie in Texas. How you doing, sweetie? Hello, Sherry B. I'm so happy to hear that. Welcome home. What a great start to 2025. Hello, Iowa Kimberly. Happy New Year. Hello, Shane. I'm happy to see you, sweetie. I'm glad you're okay. Just the phone had a little incident, I hear. Hello, Eileen E. Carlin. Ooh, Georgia. I take it you've already crossed the threshold of the year. I am geographically declined, so yeah. I always say I'm directionally illiterate and geographically declined. So I'm playing this one. I really am. I'm playing this one. I'm pretending I know where things are at that I don't know where things are at. Hello, Catherine Gaston, my love. Yes, faithful night crew it is. Happy birthday! You're a New Year's Eve, baby. That is so cool. Congratulations on 67. Oh my gosh, what a blessing. You're amazing, and I love having you here every night, and I'm so grateful you're a part of my life. the missus. I'm sorry. You're welcome to join too. Maybe on another phone in another room. Y'all can pretend like you're strangers for the night. Do that whole pretend mock meet at a bar thing, in your living room or whatever. Oh, that's a good point. Hello, Michigan Urbex. How you doing, sweetie? Well, you got to see Billy right away when we opened up. Oh, he is so cuddly today. Earl is his usual talkative self. Tiny Kitten Esquire is her usual skittish self. I really got to get her fixed. I think that'll make a big difference in her personality. That's kind of tops of the list for 2025 is getting Ava and Tiny Kitten Esquire spayed. The boys are neutered because I refuse. Like, I prefer male cats. I refuse to have a non-neutered male cat. Tom smell is not good. So yeah, they got fixed right away. But the girl kitties, Bandit came fixed, and Tiny Kitten Esquire, I just haven't gotten there yet. It's expensive. It really is. It's expensive. But life happens, Hi, you've got a very cold nose. You've got a very, very cold nose. You want to come say hi? The neighbors are doing fireworks, and Ava really hates them. They scare her, so she cowers at my feet, and then she puts her very, very cold nose on the underside of my arm, and it's so cold, and it just sends this like chill all down my spine. It's treat time. It is Blue Buffalo Health Bar's treat time. Compliments of Grandma Bonnie. She's so gentle with it tonight. Wow, she must be scared. Oh my gosh. The chat's moving so fast that I know we're almost there, guys. We are almost there. Let's get an exact number, right? Because it's that is a wet nose. How'd your nose get more wet? How did it get more wet? Gross. We're at 3,991. Are there 9 people out there who haven't subscribed that would not mind becoming a part of this channel and pushing me to 4K? I've actually got 6 minutes left before the new year. 6 minutes to come up with 9 people. Y'all got 9 friends? Anybody? I mean, I try not to beg, but hey, I know you can count. It's 3. Oh, there's Earl. Napping on the bed. Ooh, I love ideas. Not here though. I know, y'all are time travelers. I know. 9. We can do it. Everybody, go create another email. No, I'm just kidding. I'm kidding. Yes, that's Earl Grey, the beautiful kitty. Oh, he's so sweet. He's like a ferret, but still a cat. Hello, Jess. Welcome. Where is here? Oh, Michelle Moreland. I know that, sweet love. Welcome, honey. Happy New Year. just not in the way most would think, Happy New Year, Chinny! Thank you for being here, and thank you for being a part of this amazing year. Yes! West Virginia in the house! Oh, thank you so much. You don't know what that means to me. I'm afraid. No way. Yes. Oh my gosh. And it's 11:56. What did you do, Fozzie? Is that legit? Like, I'm at 4,001. You guys, we made 4K. We did it. We made 4K. I cannot even believe that. Next one's on me, Fozzie. Oh my gosh, thank you guys. Oh my gosh. You are so great. I feel like I cheated, but at the same token, I'll take it. Yes, we did it. Yay! Hippie TIO. Oh my gosh. 4,001. 4,001 amazing, beautiful friends you guys are. Oh, you like to win. Oh, this is so great, you guys. Thank you. Ava, come say thank you, baby. Come on. Fireworks are done for the minute. Oh my gosh, she won't even crawl out of here. Ava, come. There's a good girl. You know they only subscribe for you. Look how calm and gentle and just timid she is right now. This is Ava on fireworks. Mortimer Duke. Hello, love. Yeah, it'd be like that sometimes. We did. Thank you so much. Oh my God, you guys are the best. I can't believe you did that for me. You guys are so great. Oh, she is. And she's so gentle and kind and sweet and loving. I can't say enough good things about my girl. Oh, sorry. Oh, I have this one hair that keeps it's part of my bangs, and it keeps like trying to mutton chop me. I know, 1 minute left of 2024 over here. And then it goes into 2025. Oh, that's such a scary thought. Hopefully 2025 is going to be so much better. I have so many prayers. 9, 8, 7, 6, 5, 4, 3, 2, 1. Happy New Year! Yay! Oh my gosh. My neighbor's doing fireworks and he just lit one off. I guess he heard me counting. Oh my gosh. Happy New Year, everyone. Hold on. Happy New Year! It's a wonder they tolerate living next to me. Yeah, Happy New Year. they're really going at it. All right, there. Now you guys will be able to experience the fun. Happy New Year. Oh my gosh, Happy New Year, Sir Philip, even though it's already been the new year for you. I'm not making it that far. Well, actually, you know what? I plan on living forever, and so far, I'm doing pretty good. Well, I mean, we count it down, but we don't. We watch usually. Okay, well, I don't, but I know other people watch the ball drop in New York, and I think that's kind of the official. But we don't have our own ball. I have a ball. Like every night, I have a ball hanging out with you guys. Ooh, Italian sponge cake, tiny wine grapes, mascarpone, smoked salmon. All right, I'm on my way. Guys, I got to wrap it up. Catherine Gaston's got food. Thank you so much. Yeah, that's what the fireworks are for. Happy New Year, Nina Sage. I knew someone was going to go there, and I'm not surprised it's you. He calls them mortars or something like that. They asked permission, like, before if they could light them. And I was just like, yeah, I don't care. Go ahead. Whatever. Yeah. Mine is more like, you know, the song, you know, in AC/DC, you know, it's kind of like that for us, you know. I'm talking about, you know, a ball with dancing and waltzing, and you're not. Jody Gardner and Papa Les, hello, I love you, and Happy New Year. Oh. Alabama, that's where you're at with your pork butts tonight? Neon green balls. Probably the grapes. I'm assuming you're talking grapes. Rebecca Douglas, Happy New Year. Oh, you guys, this is just, how wild. What an amazing, amazing group you are. Oh, Ava's gone. She went on the move. She's gone. All right, it's kind of freezing outside. All right, guys. So, oh, my daughter was a tennis player, so there's tons of those all around the house. You know, I always thought having a dog that, oh, cool. Once she's done with tennis, then we would have, then I'd be able to play fetch with Ava. But Ava don't play fetch. Ava don't play anything. The only thing she does is cuddle and love. I'm okay with it. Let's happen that Happy New Year. Thank you. Mortimer Duke. First super chat of 2025. Thank you so much. I love you. Let's see if he's still there. Oh, nope, he took off. Yeah, they all took off. I love him. I love Papa Les and you so much. Just go up to him and give him one of these for me. Thank you so much, Shane. It was a group effort. You guys are just so great. Thank you so much. Yes, Iowa Kimberly, thank you. This is just wild. Okay, take a tennis ball, cut a slit in it, and put Ava treats into it. You will create a tennis ball maniac. Ooh. Ava does like food. She does like treats. That might have to happen. Thank you. I really think they are too. They're so cute and snuggly. Falling asleep in Billy's fur was both great, and I woke up all snifflies. So it sucks when you're allergic to the thing you love most in life. But it was a great nap. I needed it. Nothing better than a nap with love. Try refreshing. Like with the it looks like an arrow in a circle. Try that, and it might, because oh, excuse me. All right, I'm gonna refresh because I'm at 4,001. But now that I refresh, oh, and then I bumped it over. Oh, come on. What did I hit? I hit something. Oh, there it is. All right. 4,002. Right there. That is so cool. That is so, so sweet. Thank you, Lisette Bennett. You're amazing. Time flies when you're having fun, doesn't it? Well, that's where it's supposed to be. 4K, baby. Oh, now we got to set goals for 2025. You know what? I'm happy with 4,002. If it stays there, I'm still okay with it. I mean, I'd like more, but I'm not going to be greedy about it. Okay, guys, I'm going to put the cases on. I got to go check on Ava. Oh my gosh, you're almost at a year. That's so great. How wild. And I've got, just so you know, this first set is about 25 minutes long, with a couple different cases. And then the next one is still exporting. It's about 45% right now. But that one is an hour and 45 minutes. Don't know if we'll watch it all, but it's a couple of cases in Michigan with Judge Stasha Buchanan, and then it is the 5201 district. I have not watched it. I edited out all the time gaps to make it palatable, but I don't know what we're going to find in it. It's a mystery. We'll have swear-tos, and then later on the cases. So it'll be, tonight is somewhat of a mystery. What a way to start 2025. I clickety-clicked.
Court is on the record in City of Conneaut versus Brandon Wells, case number 24 CRB 225. On November 20th of 2024, in this case, Mr. Wells pled no contest and was found guilty of 2 counts of violation of a protection order, each of which is a first-degree misdemeanor, and telecommunications harassment, a first-degree misdemeanor. As part of his sentencing, in subcase A, one of the charges of violation of protection order, I did sentence the defendant to 180 days in jail, which in subcase B, on the other charge of violation protection order, I suspended 180 days in jail, placed the defendant on 3 years of supervised probation, amongst other things, and ran that sentence consecutive to all of their sentences. And then in subcase C, the telecommunications harassment charge, I did run that sentence. I merged that sentence in that charge with the subcase A charge of violation protection order. So Mr. Wells was taken into custody that day on November 20th, 2024. I issued a commitment to the Ashtabula County Jail. On December 20th, 2024, the court received a letter from Mr. Wells, more or less asking that I modify his sentence. I did go ahead and set a hearing on his request for today, and Mr. Wells is appearing at this hearing by way of video from the Geauga County Jail, which is where Mr. Wells is currently being housed. Present in the courtroom is his attorney, Philip Heasley. Now, while Mr. Wells submitted this letter directly to the court outside of his attorney, Mr. Wells was represented by the Public Defender's Office throughout this case, and so it was scheduled with other cases today in which the Public Defender's Office was present. So Mr. Heasley is present to represent and advise Mr. Wells if he needs it. He is in the courtroom appearing at table 2 on the video. Also in the courtroom is Law Director John Lewis, who is appearing at table 1 on the video. Okay, Mr. Wells or Mr. Heasley, this is Mr. Wells' request or motion. Go ahead.
Thank you, Your Honor. I have read the rather heartrending letter that Mr. Wells wrote to the court, and I'm sure he's appreciative of the court granting a hearing on said letter. I do not know the exact circumstances of his Geauga County incarceration. He lays out what seems to be a request for a furlough in his handwritten letter of December 20th, based upon his father's returning cancer, which is, of course, sad. To my knowledge, Your Honor, this involves his father, not his ex-wife, soon-to-be ex-wife, or the children. In fact, in the letter, he says, "I want to have nothing to do with my kids anymore." His focus seems to be on spending some time with his dad and to help his mother. I do not know how serious his father's illness is, but it sounds that it's quite severe based upon Mr. Wells' letter. We would hope that the court would modify to some extent Mr. Wells' sentence to allow a furlough with his father and mother, to allow him to spend time with them, his father in particular, Your Honor. Again, I do not know the circumstances of the Geauga County confinement. I will let Mr. Wells address that issue. With the stipulation, which is, I think, what has sort of landed him in trouble in the first place, that his wife and children be avoided. And that's all, Your Honor. the rest, I think Mr. Wells can provide himself. Thank you very much.
Okay, Mr. Wells, is there anything you would like to say for the court to consider? I can't hear you, Mr. Wells. Oh, wait a minute, give me 1 second. I'm sorry, that was my mistake. Okay, go ahead, I'm sorry.
I want to apologize to the courts and to Amber Wells or Amber Catanzaro for everything that's happened. I've learned my lesson. While I was in here, I found out my dad's cancer had came back and he is not doing very well. And I would just like to be out there to help him and my mother as best as I can.
So, Mr. Wells, you're sitting in my chair and you're having to make a decision to modify someone's sentence. And you receive a 3-sentence letter from someone, handwritten letter, and then you make your claim here in the last, what you just told me was less than a minute. So how would you decide? I mean, I guess the point I'm trying to make is, don't you think you would provide me more detail about what the situation is and why you need to be released early? I mean, this is a serious request. Just to say that, I've learned my lesson after 30 days, and my dad's cancer has returned. Is that good enough for me to consider just based? Should I take your word for what you say?
30 days of a 180-day sentence. He's doing well.
I'm just nervous. I have a lot of things going through my mind right now. I just lost for words right now.
I mean, you're sitting in jail. Why don't you write out what you're going to tell me? I mean, why aren't you reading something that you're going to explain to me? I gave you an opportunity for a hearing. 9 judges out of 10 would have denied any request for a hearing. I'm giving you a chance for a hearing, and yet you don't even tell me the circumstances.
I found out that my dad's cancer came back, that he's not doing very well.
What does that mean? What kind of cancer does he have?
Pancreatic cancer, and then he has lung cancer. And the fluid in his lungs came back, and he had to have chemo, just started chemo. I haven't really talked to him too much, so I don't know what's exactly going on.
Do you live at home with your dad? Do you care for him? I mean, what was the circumstances before you...
I live at home, I'm sorry. I live at home with him, yes I do.
So,
and that he had to quit his job, or he had to retire from his job because of the severity of his cancer.
So before you were incarcerated, you were living with your dad?
Yes.
How long were you living with your dad?
For 2 years.
Was anyone else living with him?
My little sister and my mother.
Okay, so your parents, father and mother, are still married?
Yes.
And they live together?
Yes.
So is there someone else to care for your dad besides you?
My little sister is 16 years old.
Okay, what about your mom?
She's able to, but she can barely afford the bills that they have together.
So it's about money, providing financial
It's not money, it's to help too, to be able to help.
How much help do you think he was when he was living with his parents prior to being incarcerated?
Has your dad received a prognosis?
Not that I'm aware of yet.
Has he had pancreatic cancer before it came
Yes,
back?
he has.
How long has he been diagnosed with pancreatic cancer?
It's been 5 years.
Well, I mean, he's quite a survivor to survive 5 years with pancreatic cancer.
And they said he had 5 years and it had a chance of coming back, and he came back.
Okay, is there anything else you would like to say for me to consider before deciding?
That I've learned my lesson, that I want to have no contact. I just want to be out there to spend time with him in his last few days. From what I've heard, that he's not doing very good.
And who'd you hear that from?
My mother.
Okay. Anything else, Mr. Wells?
No, Your Honor.
Okay, Mr. Lewis.
Your Honor, I have an objection to this. The relief sought by Mr. Wells on several different levels. The first of which being that Ohio trial courts do not possess the inherent authority to suspend, cancel, or modify a criminal sentence once that sentence has been executed, absent specific statutory authority to do so. That is from a case called State versus Roe, 118 Ohio at 3rd 121. Also some other case law on that subject. But Your Honor, I haven't heard a word from Mr. Heasley or Mr. Wells under what statute or authority this court has the ability to modify his criminal sentence, which has already been executed. Aside from all that, the court is well aware, as I am, as the city of Conneaut is, of the numerous cases Mr. Wells has had before this court involving his ex-wife, Amber Wells, his minor son, both of whom are present in the courtroom, I would add. I discussed the matter with them prior to going on the record in this case. They are adamantly opposed to the relief sought by Mr. Wells. Basically, Your Honor, his behavior, not only in this case, but in all these other cases, Your Honor, 24 CRB 180, 24 CRB 144, 24 CRB 96, 23 CRB 269. Those are just four. There may be more cases, Your Honor. I only have one file with me, so I'm going from my notes here. But these are all cases involving Mr. Wells' utter disregard for a for a domestic violence protection order issued by the Court of Common Pleas.
So he's a serial violator.
Asheville County Court of Common Pleas in case number 24 DR 148. That protection order is still in effect to this day, Your Honor, as well as at the time that he incurred charges related to that order. This is, I can't think of another example in my time here in Conneaut Municipal Court where there has been more of an utter disregard for a protection order, frankly. Again, I spoke to Amber Wells, who's present, and the minor child, who is also a victim in these cases. They're adamantly opposed to the request from Mr. Wells, and they feel, as do I, that the violation of the still in effect protection order will begin the moment that Mr. Wells is out of jail. Thank you, sir.
Thank you, Mr. Lewis. Do they wish to say anything to the court?
I just want to say that he knew his father's illnesses almost 6 years ago, and it did not stop him continuously these past 3 years of continuous harassment in his behavior. So now all of a sudden, which he knew his dad was ill, now all of a sudden he's learned his lesson. I'm not buying it at all. It's an excuse. And I'm sorry, but I also think that him being in his parents' home would probably be more of a burden than a help.
That, for the record, that was Amber Wells?
Yes, sir.
Okay.
So he's known his dad has had pancreatic cancer for 6 years, and it didn't matter to him before, but all of a sudden, 30 days into a sentence, now it matters.
Mr. Heasley, any response? Thank you, by the way, thank you.
Just as I may have mentioned earlier, Your Honor, in his, Mr. Wells, it's not uncommon for pro se litigants to not exactly specify what type of relief they want the court to grant. I used myself, I believe, the word furlough to give Mr. Wells an opportunity to see his dad. As far as I know, courts grant furloughs regularly for good reason. And I think he's given one here, although the details aren't completely spelled out. He is incarcerated. But on another matter, as I also mentioned earlier, this involves my client's father rather than his wife or now ex-wife or child or children. In fact, he says, I want to have nothing to do with my kids anymore. He wants to spend the last few days I can with my dad and to be able to help my mom. So I think what Mr. Wells is requesting, and which would not be prohibited, would be a furlough granted by this court to allow him to see his father, while of course the protective order against Amber Wells and anyone else in the order remaining in full effect. So we would hope that he could be able to see his father, Your Honor, at least for a short period of time. He has been incarcerated for a lengthy period of time, and I think everyone in the courtroom certainly wishes that there be no more problems between Mr. Wells and Ms. Wells and anyone else. That's all, Judge. Thank you very much.
Thank you, Mr. Wells. Do you have any last response to what was said in the court?
I do not want to have any more problems with the courts. I seriously would like to spend time with my father. I would not have zero contact with them at all. I give you my word. On my father's word, I would not have any contact.
Oh, you are just a shiny turd.
I just would like to spend time with my father. That's the only thing I ask for.
Okay. Based on, first off, in response to Mr. Lewis's argument that the court has no authority to modify sentence, I disagree with that. I think that issue's been brought up by the law director's office in the past. In other cases, I do find that I do have authority to modify a sentence, although I'm not going to do it in this case. I just don't have enough evidence, information, documentation, you name it, that supports the defendant's request to modify his sentence. I will deny his request, and this matter is concluded. Anything further, Mr. Lewis?
No, sir, thank you.
Mr. Heath? Nothing. Thank you. Okay, this matter is concluded. Thank you, officer.
Thank you.
I swear on my father's like, how inconsiderate can you be that you're swearing on your still alive father's grave? Impending doom already, like, I can't believe he's such a jerk. People like that suck.
Get an order out. Court is calling at this time City of Conneaut versus Jennifer Baker, case number 24 TRD 574. Court will note in this case Ms. Baker pled not guilty to one count of driving under suspension, an unclassified misdemeanor. On September 3rd, 2024, we attempted to conduct a pretrial conference on September 24th, 2024. The defendant failed to appear at that time. I rescheduled that hearing without issuing a warrant. It was rescheduled for October 15th, 2024. Again, the defendant failed to appear. I issued a warrant at that time, and then set a bench trial for November 5th, 2024. On October 16th, 2024, Ms. Baker did appear. I did recall the warrant and set a pretrial conference for October 29th, 2024. At that time, Ms. Baker asked that, in writing, asked that hearing be rescheduled. So I rescheduled it for November 5th, 2024. it was at that time we scheduled it for a bench trial. The defendant did appear. We scheduled for a bench trial on December 3rd, 2024. And the prosecutor was here. The officer was here to testify, and the defendant failed to appear again. And so I issued a warrant. Ms. Baker is appearing, turning herself in on the warrant. So Ms. Baker, can you explain to me why you failed to appear for your trial on December 3rd?
I had the dates in my head mixed up. I thought it was the 5th because my cousin had it on the 4th, but I found out when I called up here that it was on the 3rd. But I also work night shift, and I also have 7 children, and my van also just went down, and I just had to get an alternator put in my van. So I was literally stranded for about a week, maybe almost 2, with trying to find rides.
I understand that. I really do. I understand that you've got things, but you want a trial.
I do.
You pled not guilty, and you want a trial.
I do.
And so we gave you a notice. It has December 3rd. It has your signature on it,
I know,
showing that you got
just
through.
said that I mistakenly
Okay,
mixed up
but
the
why?
dates in
Here
my
we
head.
are on the day after Christmas. You just called recently. Why
I
didn't you
called
call the
before
court that
Christmas.
day?
I called on the 5th. You guys were not open.
I don't want to hear it. So let me ask you, if I schedule this for a bench trial, are you going to show?
Yes, I will.
Okay. This will be the second time that I've lifted a warrant in this case on an unclassified misdemeanor case, not even a jailable offense case.
Is
The
you
second time
serious?
because you failed to appear. Don't argue with me.
I'm
Your
not
failure
I
to
asked the
appear.
question, is you yelling appropriate?
Yes, it is.
Because I don't feel that this is that extreme that you need to
It is
yell.
extreme because you keep failing to appear. I had an officer, there was an officer here, inconvenienced for your failure to appear. He was here to testify. He sat at table.
Testify what? That he pulled me over and let me know my license was suspended?
That's what the purpose of a trial is, Ms. Baker.
Mail.
Right now there's a warrant for your arrest. Right now there's a warrant for your arrest.
Okay, and I'm turning myself in on the warrant.
Okay, well then we'll take you down to jail. There was an officer here inconvenienced as a result of your failure to appear.
You act like I did it on purpose.
Ma'am, I'm not saying you did it on purpose, but how do I send a message to you to be here when you're supposed to be here? Okay, stop talking! Stop talking! That's why I have to raise my voice. Stop talking! For the second time, I will lift the warrant. One more miss, one more failure to appear, it's not going to be continued again. One more failure to appear, I will issue a warrant, and when it is executed, you will stay in jail. You want your trial, you want your day in court, then show up. Bench warrant is hereby lifted. This case will be set for a bench trial. You'll go to the clerk's window, they'll give you a date and time for your bench trial. Okay, this matter is concluded. Go to the clerk's window, they'll take care of you.
Yeah, she wasn't getting it. She just wanted to argue. The judge saw you. Oh, hi, baby girl. You come back out to play? Probably. I wouldn't be surprised. She's heading to Walmart after court. So the cases that I'm exporting, they're at 89.8%. So they got a minute. Hey, I said that he's a hothead when we start when this started, before I even played it. I said he's a hothead. But he's got points. And she wouldn't listen. She wanted to keep talking. I think he felt the increased where are you going, baby? I think he thought the increased decibels was necessary just to get the point through to her. Oh, there you go. Now you back. Oh, is it because Billy's up there? Come on, baby. Come on up. The whole world wants to see you. Oh, starting the new year off right with Ava. What tags? The raging and exploding? Oh, I don't see they have all this stuff in the YouTube studio for content creators where they'll like write your descriptions for you to make them more engaging or convincing to people to show up, make people want to see it more. I write my own. Mine are probably pretty lame, but I already told you guys I don't like all that AI stuff doing stuff for me. Maybe I'm a little bit of a control freak. I don't know. Probably not. I just prefer the real human connection, even in the digital age. She's so pretty. And the fireworks are over and she's still hiding. Yeah. Yeah. I've seen, you can tell some of them because they don't even use proper English. And it's frustrating to me, to have it so, yes, so clickbait. Yeah, it makes claims that just aren't true on a lot of them. It's ridiculous. And then you go and watch the case and it's like, that never happened. When did they say that? When did they do that? What was that about? Like, at least mine, what you're getting. If I try to use a quote often, or be realistic about the expectations of it. And yeah, I know it costs me viewers, but at least people know that I'm not lying to them. And to me, that's kind of worth more. I am going to get ahead of this game because it's at 95.9%. So I am going to, it never lets me click it on the first click. Clickety click, click, click. Trying to safely eject. Trying to be responsible about it with my hardware here. And it's not wanting me to. Tiana Miller, you made it! Happy New Year, my love! I'm so happy to see you. All right. We've probably got, I don't know, it's 97.3, so it's moving pretty quickly. So we don't have long. It's like not long enough to justify running a 20-minute body cam vid or something like that, which would ultimately demonetize the whole stream. Every time I do that, I learn the hard way. I learned the hard way that they don't like when I do that. So, we can go on a field trip, Oh, wow. It's at 98.3. It's going fast, guys. It's going fast. So, I want to hear what your guys' plans are for the new year. Like, I'm not a big New Year's resolution kind of person because who keeps them? Really? Like, my goal in life every day is to be a better person than I was the day before. So, for me, every day is a new resolution. But I know a lot of people do subscribe to the new year, new me kind of way. This isn't a comedy stream. Sorry, I love you. Guess what? Guess what just finished? If you couldn't tell. I love you. Hey, I am. Do you know how much taking care I'm doing? He's taking care of my whole desk right now. His tail is thumpity thumping. He's mad that I just picked him up. How dare you, human? All right, now I need to put this onto the right one. Oh, I always do that. I leave you're rolling onto the keyboard. You are going to eject me. This is a very large desk. I don't know how it's not big enough. I have got that goal down pat. Every day I win on that one. Now do you give things up specifically, or does it change every year? Yeah, I just think when it's sensationalized with the New Year's goals and resolutions, I think when it's sensationalized, it's not as like it doesn't mean as much to yourself when it's like I'm gonna change this for the new year, and like I said, who keeps them? Who really does that? I've never known as a single person to keep a New Year's resolution. I might be wrong, I'm sure they exist, but I just have not had that experience. Oh my God, is he ever? They really are. They're spoiled rotten and they know it too. You make this hard, Billy. You make this very difficult, but I love you. You're the best. Oh, I got a slow blink. And a tail flop.
All right. If you're ready, we're ready. I have, looks like Ramon Crawford on top here. on the record in state of Michigan versus Ramon Crawford, 2301383 FY. Appearance, please.
Good morning, Your Honor. Tyler A. Smith from the Office of the Public Defender here in Ingham County. I appear on behalf of Mr. Crawford, who's appearing separately via Polycom from the Lansing lockup today.
And you, sir, are you Ramon Crawford on the video here?
Yes, ma'am.
All right, Mr. Crawford, this is your arraignment. What I have here is a felony complaint. This alleges that on or about April 6, 2023 at 737 Wisconsin Avenue, City of Lansing, Ingham County, Michigan, count 1, home invasion first degree, that you did break and enter or enter without permission a dwelling located at 737 Wisconsin Avenue, and while entering, present, or exiting the, did commit an assault, and while entering, present, or exiting the dwelling, Jonathan Ellis was lawfully present therein. This is a felony punishable by 20 years in prison and or $5,000. A consecutive sentence may be imposed for any other conviction arising out of the same transaction. Count 2, assault with a dangerous weapon, that you did make an assault upon Jonathan Ellis with a dangerous weapon, a baseball bat, but without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder. That's a felony punishable by 4 years in prison and or $2,000. DNA to be taken upon arrest. A consecutive sentence may be imposed if the assault was committed in a place of confinement. Count 3, assault with a dangerous weapon, that you did make an assault upon Deontay Ellis with a dangerous weapon, a baseball bat, but without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder. Felony 4 years and or $2,000, DNA to be taken upon arrest. A consecutive sentence may be imposed if the assault was committed in a place of confinement. Count 4 is assault with a dangerous weapon, to make an assault upon Joseph Brown with a dangerous weapon, a baseball bat, but without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder. Felony 4 years in prison and or $2,000, DNA to be taken upon arrest. A consecutive sentence may be imposed if the assault was committed in a place of confinement. Do you understand the charges and the possible penalties?
Yes.
Mr. Crawford, you have the right to have an attorney in this matter. If you'd like to have an attorney, but you don't believe that you can afford one, we can see if you qualify for the public defender's office. You have the right to have a trial. That could be by jury. You have the right to remain silent. Anything you say orally or in writing will be used against you in court. You have the right to have an attorney present with you during any questioning by law enforcement. Do you understand these rights so far?
Yes.
Are you requesting a public defender to assist you in this case?
Yes.
Mr. Smith, you successfully did an intake in this case?
Yes, I've compiled the application. I'll forward it on to my supervisors immediately.
Thank you. All right, Mr. Crawford, since you have felony charges, you do have the right to have a preliminary examination. That is a hearing where the government must bring some evidence to demonstrate probable cause to believe that the felonies occurred and probable cause to believe that you're the person who committed these felonies. Before we proceed to preliminary exam, you'll have a probable cause conference, a day where you, your lawyer, and the prosecutor make sure that you have all the evidence and information you need for your preliminary exam. Probable cause conference will be January 10, 9 a.m. with Judge Flores. That's what they say, although this file is stamped Judge Ward, so if Judge Ward's around, they might give it to her. If she's not around, it'll go to Flores. Preliminary exam will be January 17, 9 a.m. Also scheduled currently with Judge Flores. All right. Now that first hearing, the one that's on the 10th, you might be able to do by video conferencing like we're doing now. But if you can't video conference, don't know how, your phone doesn't work, you should come in person. And that January 17 day, that is absolutely in person, as evidence and testimony may be presented at that time. It's very important that you come in person. Now, are you on probation, parole, or bond to any court, sir?
No, this is the first time I ever been in trouble.
You picked a heck of a way to start your criminal career, my friend.
Okay. All right, now the address they've given me, well, I've got two different addresses for you, so I guess I need to know which one's current. The one on Rio Road, is that the current one?
Yes, ma'am.
Okay. And that doesn't involve being around any of the people that I mentioned, Mr. Ellis or
even know
Mr.
these
Ellis or Mr.
people.
Brown? You don't know them? Okay.
Know these people.
Okay, just making sure that you're gonna stay separate because that's gonna be a bond condition.
He don't know them? How do you wield a baseball bat at two people and you don't know them? At their home.
Now, this Rio Road address, should I have an apartment number or anything with that?
That is the apartment number. When you, it's a townhome. So when you, look up the
Okay.
address, yes, it pulls up as that specific unit
That's the-
number.
That's the whole address.
Yes.
Okay. What's a phone number you can be reached at?
I have two, 404-337-7549-586-790-0709 as well.
Did you say 0709?
Yes, ma'am.
You realize that no person can write as fast as you were saying that? That was really unreasonable way to deliver that information.
I can't hear you. What? You
You
said,
said, when someone asks you for your phone number and I have to write it down, don't deliver it that way. That's not reasonable for you to expect me to write that fast.
oh, sorry.
Man,
That's the way I talk.
I know, but I'm trying to copy it down accurately, just in
Okay.
case.
That's 586
I think I got it.
790-0709.
Yeah. And you didn't just do that with one phone number, you did it with two phone numbers.
It's programming.
All right, Mr. Smith, I have, as far as Mr. Crawford's Michigan criminal history here, it shows nothing of note, just as he told you.
Mhm.
All right, Mr. Smith on bond.
Yes, Your Honor, I have little doubt the court will have some concerns due to the nature of the allegations. However, as the court has stated, there is no criminal history for Mr. Crawford. This is the first encounter anyone knows of between Mr. Crawford and the criminal justice system. I think that speaks to the way Mr. Crawford has conducted his life to this point. More to the point, the general factors the court considers, that is a risk to the community and risk of flight. I have no reason to believe Mr. Crawford is a risk of flight. Not only is he employed, he also acts as a caregiver for his sister, who I understand is disabled, as well as his sister's 3 children. Suffice it to say, Mr. Crawford has many responsibilities and several people who rely on him for income, care, and the necessities of life. I would respectfully submit that keeping Mr. Crawford in custody would not only not serve any useful purpose, it may actively complicate the lives not only Mr. Crawford, but those who rely on him. To the extent that the court may have concerns, as I said, about potential law-breaking activity, given the nature of the allegations, I respectfully submit that with appropriate bond conditions, any such risk could be mitigated. I will leave it to the court, of course, to determine what appropriate bond conditions may be. But for these reasons, I am respectfully requesting the court set a personal recognizance bond with any conditions the court may find to be appropriate.
I'm just looking up, so this is a co-defendant case, and I just want to see what the status of that case is. So just 1 second here and see if I can find it.
If the court is so willing, I would like to know the co-defendant name so we can check for conflict.
On the complaint, it's Shakia Mitchell, and Mitchell is Mitchell. Shakia is Shaquilla.
I don't know that person.
And it looks like that's still in warrant status. Let's see here. She was arraigned, bond posted, bond revoked because she removed her tether. And that's it. She looks like she cut her tether and disappeared a year ago.
Okay.
Or is
That
that-
would be important for conflict check, as I do see that we have at least some information about an individual by that name. Mr. Crawford, I would avoid making any comments with regard to the case.
Ooh, he
I
cut him
don't
off.
speak to these people. I don't even know.
Mr. Crawford,
Mr. Crawford, your ability to follow directions is very important to me right now. So when you're being given a direction and you don't follow it, I take that into consideration in deciding whether you're going to follow your bond. So when the lawyer says don't talk, don't talk. Okay? He's trying to give you advice for your protection, and I want to assess whether you're going to follow my court orders if I let you go. I'm considering the fact that Mr. Crawford's accused of some pretty serious things, but that they are also alleged to have occurred almost 2 years ago, like more than 1.5 years ago. He has no prior criminal history. He has a local address and ties to the community. Based on all of that, bond will be set at $11,000 personal recognizance. What that means, Mr. Crawford, is I'm going to release you without posting any money. But you have to follow the rules that I give you in order to stay out of jail. Firstly, you must attend all of your court dates. It's actually a bond condition that you attend, and you've been given 2 of them, January 10 and January 17. You are not to leave the state without permission from the court. Do not commit crimes while you're out on bond. Notify the court in writing if you change your address or telephone number so that you can get important court information. It is a bond condition that you notify us if you change your address or telephone number. You must notify us in writing. Do not use alcohol, marijuana, or illegal drugs while on bond. Do not possess or purchase any firearms, ammunition, or dangerous weapons on bond. You are not allowed to possess those items at all while you're on bond. If you have them, you need to give them to somebody else for safekeeping or give them to the police because you are not allowed to have them. You are ordered to report to pretrial services within 48 hours of your release. I can tell you that they are closed today and tomorrow. So if you are released out on bond today, you need to report to them on Thursday. You should get a brochure from the jail. It has a phone number and an address so you can contact them. They just keep track of people on felony bonds. So make sure you contact them so that they don't mark you non-compliant. Do not engage in harassing, intimidating, stalking, or threatening behaviors. Do not assault, harass, intimidate, beat, molest, wound, or threaten Jonathan Ellis, Deontay Ellis, or Joseph Brown. Do not have any contact with Jonathan Ellis, Deontay Ellis, or Joseph Brown. You are not to go to the premises of 737 Wisconsin, nor within 2,000 feet of where Jonathan Ellis, Deontay Ellis, or Joseph Brown live, work, or attend school. If you violate the order of no contact, you could be arrested without a warrant. This bond could be revoked, which means you go back to jail. You could be in contempt of court, for which you face a sentence of up to 93 days in jail and or $7,500 in fines, consecutive to that which you already face. This order is about you. It's not about them. I know you say you don't know who they are. I don't really know the details of that, but what I will tell you is if they decided to start texting you or calling you, they could do that. But if you text them back or you take that call, you're the one who's under a court order. You're the one who risks going to jail. They do not have authority to grant you permission to violate this court order because it is the court's order, not their order. So if they invited you to meet up with them and you went, you would be the one who would risk going to jail, okay? You understand my order?
Yes.
Just putting a couple things on here to make sure it's clear. All right. So remember, it's very important, Mr. Crawford, to stay out of jail while you sort through all of this. You must follow these court orders I gave you and attend to your court dates. Failure to do so is what could result in you being brought back into the jail and having to stay in jail until this case can proceed. Mr. Smith, we've talked about the charges, the court dates, the bond, the conditions. Anything I missed for Mr. Crawford today?
I don't believe so, Your Honor. I certainly have nothing further.
All right, you're all set there, Mr. Crawford.
Well, the good news is he's gone 2 years without being picked up. So in that time, he hasn't, apparently been committing multiple offenses and whatnot, and it's his first offense, but wow, did he pick a doozy. I almost wonder if it was led by the co-defendant that absconded and cut their tether off, and she seems like a bad apple and maybe a bad choice for hanging out with.
And that will bring us to Leslie Buck.
How you doing? Good morning.
Hello, Mr. Buck. Just 1 second. I'm just trying to get to the right page in here. I think this is it. Okay. On the record in State of Michigan versus Leslie Lynn Buck, 2403694FY. Appearance, please.
And yes, Your Honor, Tyler A. Smith from the Office of the Public Defender here in Ingham County. I appear on behalf of Mr. Buck, who's appearing separately via Polycom from the Lansing lockup today.
And you, sir, you are Leslie Buck?
Yes, ma'am, I am.
Okay. Mr. Buck, this is your arraignment. What I have here is a felony complaint. This alleges, let's see here, that Leslie Buck used a computer to submit fraudulent Growing Michigan business grant applications to the Michigan Department of Treasury between the dates of November 15 of 2021 and June 1st of 2022. Buck certified the truthfulness of the applications under penalty of perjury, even though he submitted falsified tax information with the grant applications. Buck knew the tax information was false because he submitted identical tax information for multiple individuals. Count 1, perjury other than court proceeding. Did, being a person authorized by statute of the state to take an oath or of whom an oath was required by law, willfully swear falsely before the Michigan Department of Treasury on a matter for which said oath is required. Defendant certified the truthfulness of the Growing Michigan business grant application, but submitted false tax information with the application. Felony punishable by 15 years in prison. Count 2, perjury other than a court proceeding. I'm going to say 7 of these counts may be identical, but I don't know till I read them aloud to you. That you did, being a person authorized by statute of this state to take an oath or of whom an oath was required by law, willfully swear falsely before the Michigan Department of Treasury on a matter for which said oath is required. The defendant certified the truthfulness of the Growing Michigan business grant application, but submitted false tax information with the application. Felony, 15 years. Count 3, perjury other than a court proceeding. Did, being a person authorized by statute of this state to take an oath or of whom an oath was required by law, willfully swear falsely before the Michigan Department of Treasury on a matter for which said oath is required. Defendant certified the truthfulness of the Growing Michigan business grant application, but submitted false tax information with the application. Felony, 15 years. Count 4, perjury other than a court proceeding. Did, being a person authorized by statute of this state to take an oath or of whom an oath was required by law, willfully swear falsely before the Michigan Department of Treasury on a matter for which said oath is required. Defendant certified the truthfulness of the Growing Michigan business grant application, but submitted false tax information with the application. Felony, 15 years.
Apparently he did this like 7 times. I think they misunderstood. Those are just each one of his personalities that he considers employees for his entrepreneurship.
Count 5, perjury other than court proceeding. Did, being a person authorized by statute of this state to take an oath or of whom an oath was required by law, willfully swear falsely before the Michigan Department of Treasury on a matter for which said oath is required. Defendant certified the truthfulness of the Growing Michigan business grant application, but submitted false tax information with the application. Felony, 15 years. Count 6, perjury other than a court proceeding. Did, being a person authorized by statute of this state to take an oath, or of whom an oath was required by law, willfully swear falsely before the Michigan Department of Treasury on a matter for which said oath is required. Defendant certified the truthfulness of the Growing Michigan business grant application, but submitted false tax information with the application. Felony, 15 years. Count 7, perjury other than a court proceeding. Did, being a person authorized by statute of this state to take an oath, or of whom an oath was required by law, willfully swear falsely before the Michigan Department of Treasury on a matter for which said oath is required. Defendant certified the truthfulness of the Growing Michigan business grant application, but submitted false tax information with the application. Felony, 15 years.
15 years on each of these. Oh my goodness. And this is just state level. He's also going to have to contend with federal level. He's messing with the IRS. And they don't play around. They want their money.
Count 8, computers using to commit a crime, maximum imprisonment of 10 years or more, but less than 20 years. To use a computer program, computer system, or computer network to commit, attempt to commit, conspire to commit, or solicit another to commit perjury, record, or document declared pursuant to MCL 750.423. Felony, 10 years and or $10,000. Reimburse the government for expenses incurred in relation to the violation. A consecutive sentence may be imposed for the underlying conviction. I also have a habitual offender fourth offense notice. Take notice defendant was previously convicted of 3 or more felonies or attempts to commit felonies in that on or about June 20, 2018. He was convicted of the offense of breaking and entering a building with intent in the 30th Circuit Court for Ingham County. And on or about January 16, 2019, he was convicted of the offense of second-degree home invasion in the 30th Circuit Court for Ingham County. And on or about April 20, 2020, he was convicted of the offense of financial transaction device, stealing or retaining without consent in the 30th Circuit Court for Ingham County. Therefore, defendant is subject to penalties, enhanced penalties, life if the primary offense has a penalty of 5 years or more, 15 years or less if the primary offense has a penalty under 5 years. The maximum penalty cannot be less than the maximum term for a first conviction. Court shall order law enforcement to collect DNA identification profiling sample before sentencing or disposition if not taken at arrest. So with that habitual offender notice, Mr. Bach, each of these charges, counts 1, 2, 3, 4, 5, 6, 7, and 8, each become a life offense. Do you understand the charges and the possible penalties?
Yes, ma'am.
You have the right to have an attorney in this matter. If you can't afford one, we'll see if the public defender will represent you. You have the right to a trial that could be by jury. You have the right to remain silent. Anything you say orally or in writing will be used against you in court. You have the right to have an attorney present with you during any questioning by law enforcement. You understand these rights so far?
Yes, ma'am, I do.
Are you requesting a public defender to assist you in this matter?
Yes, ma'am.
Okay. And Mr. Smith, you did an intake today?
Yes, I did, and I will, of course, forward it on to my superiors.
This file is marked Flores. They gave me a notice for Judge Simmons. Judge Flores is definitely here, so I'm guessing it's actually going to be a Judge Flores case. But for now, the probable cause conference is scheduled for January 9 at 8:30.
How much you want to bet this guy also did that Chase Bank ATM scam thing where they claimed that they deposited $30,000 and then they instantly withdrew that amount out of the ATM when there was really no deposit for that amount? Yeah, I have a feeling that he's that type of person to have gotten in on that and wouldn't give two hoots that that he really didn't have that kind of money in the account at the time.
That's a day where you your lawyer and the prosecutor make sure that you're ready for a preliminary exam. Preliminary exam will be January 16 at 8:30. That's a day where the prosecutor has the burden to show probable cause to believe that these crimes occurred and you're the person who committed these crimes. So that means on January 9, if you're not in jail, you could do video conferencing for your probable cause conference, kind of like we're doing now.
Yes.
But if you don't know how to do it, don't want to do it, your phone's not working, you should come in person. The January 16 day is absolutely in person, as that's a day where evidence and testimony may be presented to show that probable cause that I just described. Are you on probation, parole, or bond in any court?
No, ma'am, I am not.
The address they gave for me on Millstream, gave me for you on Millstream Lane, is that still your address?
Yes, ma'am, it is.
Okay. What's a good phone number to reach you?
810-287-4469. 68.
Just looking at Michigan criminal history. Malicious destruction of building under 200. Oh no, that was dismissed. B&E with intent back in 2018. And then dismissed. That home invasion that I mentioned during the habitual. The financial transaction device that I mentioned during the habitual.
So any one of the new charges can result in life imprisonment because of his prior offenses.
And then that's it. I think his habitual pretty much sums up his entire criminal history, actually.
Yeah.
All right, Mr. Smith on bond for Mr. Buck.
Yes, Your Honor. I am aware of most of what the court has described as Mr. Buck's criminal history. I was not aware that there was a home invasion at any point. We do have some records dating back to 2019. I will point out, as I'm sure the court has already noted, that while certainly the allegations before the court today are concerning, almost all of Mr. Buck's criminal history consists of offenses of dishonesty. That is, none of these appear to pertain to possession of a controlled substance, anything of that sort. And to the extent that there have been assaultive allegations, it appears they were dismissed. With regard to the factor the court must consider whether Mr. Buck is a danger to the community or a risk, I respectfully submit that at least physically, he's no risk to the community whatsoever. With regard to risk of flight, I will note that as far as I am aware, Mr. Buck has appeared at all court dates, on one occasion perhaps a bit late, but in any event, he appears engaged with the criminal justice system and is not one to disappear, that is, abscond. Also, he's from the city of Lansing, has family here, deep roots, and while he was recently laid off from his employment, he has maintained a significant period of honest employment in the recent past. I would respectfully request the court consider release on personal recognizance here, not only due to the factors I previously stated, but in order that Mr. Buck secure new employment, maintain his housing, and maintain the other necessities of life, as the court, I have no doubt, is well aware individuals who fall into unstable housing, problems with employment, oftentimes find themselves before the court again. And that's something I'm sure we would all rather avoid. So for these reasons, I would respectfully request the court set a PR bond with appropriate conditions.
Okay. So I'll start with, these are not assaultive crimes. And while there's a lot of them, the penalties are very severe at this time. I don't believe that I can justify giving anything other than a personal recognizance bond at this time. So bond will be set at $10,000 personal recognizance, as Mr. Buck says he's not on probation or parole. His criminal history, I believe, supports that. These are not assaultive offenses. He's given me an address here in the community and has ties to the community. So $10,000 personal recognizance, but the conditions of bond are an effort to, I guess, try to make sure that nothing additional occurs while this case is pending. So, Mr. Buck, your first bond condition, of course, is attend all of your court dates. I've given you two, which are January 9 and January 16. There is some chance that that court date could be changed to January 10 and January 17, but you follow through on January 9 and January 16 unless you receive information from your lawyer or the court that that date has been changed.
Okay.
Do not leave the state without permission from the court. Do not commit crimes while on bond. You must notify the court immediately if you change your address or telephone number, and do that in writing. That's a bond condition, that you keep us up to date on your telephone and address so you can receive important court information. You are ordered to report to pretrial services within 48 hours of your release, but I, of course, will tell you they're closed today and tomorrow for the New Year's. So if you get out of jail today, you need to report to them on Thursday. You should have a brochure there from the jail with their phone number and address so you can make that report. Do not use alcohol, marijuana, or illegal controlled substances. Do not possess a firearm or a dangerous weapon. And lastly, pursuant to MCR 6.106 D2, which says that I can place conditions that are reasonably necessary to ensure the appearance of defendant as required in the safety of the public. I'm going to order that Mr. Buck is not to access social media until further order of the court.
Say it again. I'm sorry. It kind of skipped when you said the last thing.
Sure. Said do not access social media until further order of the court. So that means no Snapchat, no Instagram, no Facebook, no X or Twitter or whatever the heck you want to call it.
No TikTok.
It's my understanding that you're accused of committing these crimes using a computer and social media. And so for the time being, I'm going to order that you're not to access social media until further order of the court.
Okay.
Now, Mr. Buck, if you think you're going to be sneaky and access social media, I can tell you from doing this job for a number of years now that law enforcement is sneaky too, and they will see you on social media and they will use that against you. So don't be stupid about it.
Definitely want to take this as what you just gave me as a blessing. I will not mess it up. I promise you that.
Okay. All right, so we've got the bond, the conditions, the charges, the court date. Mr. Smith, did I miss anything for Mr. Buck?
No, Your Honor, I have nothing further.
All right, Mr. Buck, remember, follow your bond, show up for court if you want to stay out on bond during this case, okay?
Yes, ma'am, I will. You have a blessed
All right.
and happy New Year's.
Thank you. You too. All right, that will conclude our arraignments for today. Mr. Smith, you're not on tomorrow. Someone else is, right?
Yes, Aaron Robinson.
Morning, Your
Good
Honor.
morning.
How are you?
You ready to do the swear it to Nissan?
I am.
Okay, great. All right, calling prosecutor order number 24-26533, People State of Michigan versus Rami Nissan, where it is alleged that on or about September 11, 2024 through September 12, 2024, the accused committed offenses of count 1, breaking and entering a building with intent, and the same for count 2 and count 3. Detective, please state your name for the record.
Detective Ryan Whiteside, representing City Troy Police Department.
All right, do you solemnly swear from the testimony you're about to give is true to the best of your knowledge, information, and belief?
I do.
Please proceed with the facts established probable cause.
Morning, Your Honor. Detective Ryan Whiteside, representing City Troy Police Department. Your Honor, these incidents occurred on or about September 11th, 2024, on or about December 14th, 2024, and on December 30th, 2024, at the same location of 5225 Crooks Road. It was on those dates at the time the building was under construction, and they had noticed scrap metal going missing on dates of September and December 14th. A camera was installed in the location due to the previous thefts, and on December 30th, 2024, The complainant called representative of Advantage Electric, called Troy Police advising that there was somebody in the building taking the copper at that time. The building was supposed to be locked up. Nobody had permission to be in the building at that time or to take that scrap metal. Officers arrived on scene, and at that time, they were able to place Rami Nissan in custody. They observed him exiting the building, and they observed the copper in his vehicle that the complainant saw being stolen on camera. That camera footage was also provided to Troy PD. Mr. Nissan was a previous employee at that location, a contractor who his access was cut off after the beginning of September prior to the first theft. He did not have permission to continue going to that location. He claimed that he was going there to recover some tools that he thought he left, and at the time decided to take the scrap metal on December 30th. In a further interview after being Mirandized, Mr. Nissan waived his rights and spoke with me. He admitted to being in the location 2 previous times, which would coincide with the September and earlier December dates, and going in knowing that he could get into the building via a small unlocked door and take scrap metal. He also admitted to knowing that he did not have permission to be in the building or permission to take that scrap metal. On each of the previous times, it was estimated that approximately $4,000 in September and $4,500 worth of scrap metal in December 14th was taken, along with the attempted about approximately $800 worth of scrap metal on yesterday's incident, for a total of approximately $9,300 of theft on the 3 events of breaking and entering. The facts of this matter were presented to the Oakland County Prosecutor's Office, who issued the request for warrant before you.
All right, the court finds the lead crime was committed, probable cause to believe the defendant committed it. There will not be any interim bonds. I'll be arraigned defendant here in a few moments. Do you have any thoughts with respect to any bond that may be set in this matter?
No, I'll leave that to your discretion.
Let's see, I'm looking through his CCH. Is he on probation for something, like a FA right now?
I don't believe so. I will double check that prior to the arraignment here. But I was under the belief that he did not have much of a criminal history, if anything. But I will double check that.
So do you think like maybe like some sort of low cash bound 10% provision may be appropriate?
Yeah, I'm okay with that. I mean, it was a place that was previously known to him. There's no violence involved in it. It was basically a crime he knew of opportunity. Yeah, I'm okay with that.
Okay, all right, thank you very much.
All right, thank you.
All right, Ms. Roberts, we're gonna head to Troy first.
Okay.
And then we'll do Novi. My inclination on the Troy is like some low cash with 10%. Because I think he's on probation right now.
Oh, he told me he'd never been in trouble before.
I think he's got a FA that he's on probation for. But
What's that? A criminal that lies? Never heard of such a thing.
Oh,
anywho,
jeez.
all right, let me get him in. All right, hello, sir, are you Mr. Nissan?
Yes.
All right, okay, calling case number 24-26533, people of the state of Michigan versus Rami Yalda Nissan. Mr. Nissan, you've identified yourself. Counsel, please put your appearance on the record. How would you like to proceed?
Rebecca Rappspring on behalf of Ms. Nissan, Your Honor, waive formal reading. My client and he is requesting court appointment.
I'm not gonna lie. He startled me.
All right, based on your conversations with Mr. Nissan, does he appear to qualify for court-appointed attorney services?
Yes, I did. He says he works for a demolition company, but he's been very slow last months and has limited.
Okay, very well. Okay, Mr. Nissan, you are presumed innocent. I'll enter not guilty plea for purposes of arraignment. I'll let you know you're presumed innocent until proven guilty beyond reasonable doubt. You've got the right to try this matter by judge or jury. You've got the right to preliminary examination within 21 days. Where the prosecutor must establish these crimes were committed, there's probable cause to believe you committed them. They've got the right to testify on your own behalf or call witnesses. If you decide not to testify at your trial, that cannot be held against you. You can try the matter by judge or jury. And you've got the right to be represented by an attorney if you cannot afford one. The court will appoint one for you, and the court will likely do so in this matter. Do you understand all that?
Yes, Your Honor.
All right. Detective, are you there?
I am.
All right. Question for you. I'm looking through his information. He may have or maybe, I don't know if this is him or not. It's a felonious assault from.
I checked his
Hometown.
CCH and we don't have anything showing on him as a CCH as far as him having a felonious assault or being on probation.
Okay.
I just checked with our lockup staff as well with the report here.
Yeah, maybe it's just somebody else, but, all right. Anyway, but allegedly the amount of controversy that was taken was like in the neighborhood of $9,000.
Correct.
Okay, very well. All right, Ms. Roberts, you may address bond.
Thank you, Your Honor. My client lives at the McKinney Drive address in Sterling Heights. He's been there for 10 years. He lives there with his brother and sister. He is a citizen of the United States. He, as I indicated, for a demolition company. His work has been slow. This is the first time he's been in trouble. I would ask for either a personal bond or a low cash.
Okay, very well. The court does have some concerns. In taking a further look at this information, appears this is a different Mr. Nissan that has the FA. This is not Mr. Ramayalda Nissan. So it may be true that he does not have any record. However, the court does have some concerns.
Maybe he is an honest criminal.
Regarding the seriousness of these matters, these are three individual 10-year felonies. The amount of controversy was in the neighborhood of $9,000. So in order to protect the public, the court's going to set bond. The court feels a personal bond is not appropriate, but a low cash bond would be. So the court's going to set bond the amount of $5,000 cash surety or 10% with the conditions of Mr. Nissan not having any contact with Bradley Lackos. Now return to 5225 Crooks Road in Troy. They not harass or intimidate any witness, that he appear for any court proceeding, not leave the state without permission of the court, that he notify the court in writing immediately of any change of address or telephone number, not possess firearms or other dangerous weapons, refrain from using any alcohol or marijuana or illegal drugs or non-prescribed medications. No new criminal offenses, and will be supervised by pretrial services. He must contact within 24 hours of his release. His probable cause conference is set for January 13th at 9 a.m. and his exam is set for January 21st at 9 a.m. Both of those at the Troy District Court. All right, Mr. Nissan, you're all set. Good luck to you. Thank you, Detective.
Thank you, Your Honor.
All right.
Have a good New Year.
Thank you. You too. All right, Ms. Roberts, let's head to Novi.
All right.
I wonder if they got the $9,000 worth of copper back from this guy and his family. I mean, it seems like that's a lot of copper to hide.
Actually, you don't need to head anywhere. You can just stay right there. I need to head to Novi.
Just sit here.
All right. My inclination on this person is a personal bond with the state of conditions. Good morning. Are you Julia Tabor? Morning.
Yeah, so this is Julia Tabor.
Okay, great. Thank you. All right. Calling ticket number 24NO04001. People of the city of Novi versus Julia Ann Tabor. Ma'am, Julia Ann Tabor. Is that correct?
That's correct.
Okay. Counsel, please put your appearance on the record. How'd you like to proceed?
Thank you, Your Honor. Rebecca Roberts, appearing on behalf of Ms. Tabor. Your Honor, we would waive formal reading. My client stands mute and is requesting court-appointing counsel.
All right, and based on your conversations with the defendant, does she appear to qualify for court-appointed counsel?
Yes, Your Honor.
All right, and then based on information she provided here on the form, that would appear to be accurate. So Ms. Tabor, I'm going to enter a not guilty plea for purposes of arraignment on your behalf. I'll indicate to you you're presumed innocent until proven guilty beyond a reasonable doubt. You've got the right to try this matter by judge or jury. You've got the right to remain silent. That silence cannot be used against you. You have the right to be represented by an attorney. If you cannot afford an attorney, the court would appoint one on your behalf. Do you understand all that?
Yes.
Okay. And then detective, do you have anything to indicate with respect to bond? I've reviewed the paperwork here, and my inclination would be to have a personal bond with standard conditions.
Yeah, she's been cooperative with us. I didn't see any warrants or anything, so yeah, we don't have no objection to a PR bond with the normal conditions.
All right, thanks. And then Ms. Roberts, do you have anything else to indicate with respect to bond?
No, Your Honor, my client tells me that she doesn't really have any kind of criminal history at all. And I would ask for a personal bond. I think she will appear for court. She has a good defense.
Okay, all right, I will set bond in the amount of $5,000 personal, so you're not gonna have to post any money to be released. The conditions are you're not to have any direct or indirect contact with Timothy Stevens or return to 3097 on Westgate in Novi. You may return one time with police to retrieve your personal items. You must not harass or intimidate any witness. You must appear for any court proceeding, not leave the state without permission of the court, notify the court immediately in writing of any change of address or telephone number, not possess firearms or other dangerous weapons, not use any alcohol, marijuana, illegal drugs or not prescribed medication, no new criminal offenses, and you'll be supervised by the district court's bond compliance program. Do you understand all that?
Yes, I do.
Okay, you're all set. Thank you very much. Have a nice day. Thank you, Detective.
Thank you, Your Honor.
See you in a little bit, Ms. Roberts.
Yep, thank you. Good luck, ma'am.
So, they're gonna send me a release. They'll probably get here in like 15 minutes, and then.
Good morning. Can you hear me?
Yes. Good morning, sir.
All right, looks like I've got 8 Pontiac cases that I need to swear to. Which ones do you have?
I only have one. I have Eric Graham. I wasn't able to get to him yesterday.
Okay.
Deputy Roberts and Deputy Miller are going to have the other ones.
Okay, great. Yeah, are they going to be calling in soon?
Yeah, I will. I'll call them as soon as I get off with you to tell them to log on.
All right, super. All right, thanks. Calling prosecutor order number 24-26479. People of the state of Michigan versus Eric Darmian Graham. Detective, please state your name for the record.
Detective Michael Hennege.
All right, do you solemnly swear affirm testimony you're about to give us to the best of your knowledge, information, and belief?
I do.
Please proceed with the facts established probable cause.
On December 28th, 2024, at approximately 12:11 hours, deputies were dispatched to 595 Going Street in the city of Pontiac, county of Oakland, in the state of Michigan for domestic violence. Upon arrivals, deputies made contact with the victim, identified as Daytania Bronner. Deputies documented that Daytania had blood gushing from his lower lip. Daytania stated that his nephew, Eric Graham, who also lives at the same residence as him, came into the house and bumped into him. When Daytania asked Eric to apologize, Eric became aggressive and struck Daytania in the face 4 times with a closed fist. Daytania stated that Eric left the house, took a chair and threw it through the front window of the residence and damaged the mailbox. Deputies documented the damage in the report. Eyewitness Christina Bronner confirmed Daytania's story. Deputies later located the suspect, Eric Graham, walking down the street. Graham admitted to deputies that he had assaulted a person on Going Street. He was arrested and lodged at the Oakland County Jail. The Oakland County Prosecutor's Office reviewed this case and wrote a 1-count domestic warrant for domestic violence and a 2nd count for MDOP less than 200.
All right, the court finds alleged crimes were committed for probable cause to believe the defendant committed them. I'm looking, it looks like he has nothing else on his record. Would you object to just some sort of a high cash value personal bond in this matter?
That's fine.
Okay, all right, we're all squared away. All right, thanks.
I will give them a call and tell them to get on now, all right? Thank you.
Yeah, thank you, appreciate it. Morning, Detective, can you hear me?
Yes.
All right, I've got 7 swear-tos left for Pontiac. Which ones do you have?
I have Shelby, Broom, Cheatum, McKinley, and Jumper. 5.
Shelby, Broom, Cheatum, McKinley, Jumper. All right, which one would you like to do first?
We can do Cheatum first.
Whatever's on top of your pile. Cheatum?
Yeah.
All right. Calling prosecutor order number 24-26464, People of the State of Michigan versus Andre Darrell Cheatum. Detective, please state your name for the record.
Detective Brett Roberts.
All right, do you solemnly swear from the testimony you're about to give is to the best of your knowledge, information, and belief?
Yes.
Please proceed with the facts established probable cause.
On the 27th of December, the arrestee, Mr. Cheatum, followed the victim from Detroit to Pontiac. When arriving in Pontiac, he exited his vehicle, fired 7 shots at the victim while she was in her car. 4 of the shots hit the vehicle. 1 of the 4 struck the victim in the right arm. They both fled the scene. Later, we located Cheatum in Detroit, conducted a search warrant, and located the handgun used in the crime.
All right, so let's see. So there are a number of counts here. So the assault with intent is based on the victim being fired on by Mr. Cheatum. And then count 2 is because there was a weapon, it's felony firearm. Count 3, carrying a concealed weapon.
Yeah, he's a convicted felon. He's prohibited from carrying any kind of weapon.
Okay, all right, yeah, all right, cool. Yeah, well, that's helpful in establishing the factual basis for the rest of these crimes, particularly the count possession of a firearm by a felony person and felony firearm. So, all right, court finds alleged crimes were committed, there's probable cause to believe the defendant committed those. There will be not any interim bond. With respect to bond in this matter, my inclination is to deny bond. What are your thoughts? But I'll listen to the defense attorney's argument. What are your thoughts regarding bond?
I would deny. He's a bitch. I mean, he's quite a few gun cases in Detroit. Some were dismissed. He did a federal time too on a gun, so he's habitual.
Okay. All right. Thank you. Which one would you like to do next?
We could do the CCW with David Shelby.
Okay. That is a swear to only, I believe. That I'm not going to do that arraignment today.
Okay.
All right, so calling case number, prosecutor number 24-26539, People State of Michigan v. Shelby. Detective, you've already identified yourself for the record and you've been sworn. Please proceed with the facts established probable cause.
On 12/30/2024 in the city of Pontiac, deputies conducted a traffic stop on a vehicle that was speeding north on Martin Luther King Drive. The vehicle was stopped. The driver, identified as David Isaiah Shelby, found to be driving. He had a misdemeanor warrant for assault. He was removed from the car. When doing an inventory search of the vehicle, deputy located a loaded firearm in the vehicle. And Mr. Shelby is a convicted felon and is not authorized to carry a firearm. He is not a CPL holder, and the gun wasn't registered to him.
All right, the court finds that the crime was committed as probable cause of belief it has been committed. There will not be any interim bond. Right, which one would you like to do next?
We can do Broom.
All right, calling prosecutor order number 24-26472, State of Michigan versus Broom. Detective, you've identified yourself for the record and you've been sworn. Please proceed with the facts established probable cause.
In the city of Pontiac, members of our directed patrol unit conducted a traffic stop at Foster and Tregent and 12/28/2004. The subject was searched and was found in possession of a crack rock. Subject was taken into custody and the vehicle impounded.
All right, the court finds the alleged crime was committed as probable cause of belief the defendant committed it. There will not be any interim bond set. I've reviewed the pre-trial services report and the police report. My inclination is to have some sort of a high cash value personal bond. Do you have any thoughts with respect to bond in this matter?
That's fine. I don't think he's a violent offender or anything like that.
All right, thank you. Which one would you like to do next?
You can do McKinley.
All right.
So on the evening of
Wait,
12.
just a second. Let me call it. This is prosecutor order number 24-26459, People State of Michigan versus Gavin Carroll McKinley. Detective Roberts, you've identified yourself for the record and you've been sworn. Please proceed with the facts established probable cause.
On the evening of 12/28/2024, actually in the early morning hours. Mr. McKinley had a dating relationship with a female in Pontiac that lived on 3rd Street, or prior dating relationship. He sent her approximately 200 to 300 text messages threatening to shoot her, kill her, injure the occupants inside the residence. He came to the residence, attempted to break in, was found out by the residents inside the house, including his ex-girlfriend, fled the scene, was pulled over shortly after by deputies and taken into custody.
All right, what did he do to the home? How did he attempt to break into the home?
He tried to kick in the front door, shattered the glass.
Okay. All right, the court finds alleged crimes are committed. There's probable cause to believe the defendant committed them. What are your thoughts with respect to bond in this matter? I've reviewed all the file. My inclination is to have some sort of GPS tether, but what would your thoughts on what type of cash bond, or should it be cash or personal? What are you thinking with respect to bond?
I think high cash bond. Judging by he sent her like 300 text messages in a matter of 5 hours. Like I said, threatening to kill her, injure her, beat up her new boyfriend. I feel like he needs to learn a lesson. And he drove. I think he lives in Clarkston or Lake Orion, so he drove a bit away to deal with her. So he seems to be a bit unstable.
Okay, and then let's see.
That might be the understatement of 2024.
Do you know anything about his criminal history?
I can look it up real quick for you if you give me a second.
Okay. Because I'm not seeing much of a criminal history.
No, I mean if you have a CCH in front of you, he doesn't really have much, but I mean there's always a first time, I guess.
Okay, so you would request some sort of a high cash bond. When you say high cash, what exactly do you mean by that?
I mean, what are you thinking? No, I'm not super familiar with the price. Or yeah, he's got a prior domestic and did probation for 12 months in 2015.
Okay. All right, we'll take all that into consideration. I'll listen to the arguments of defense counsel before I set the bond. So we've got the last is the last one, Jumper.
We get to meet these people in a minute.
Yes.
All right, calling prosecutor order number 24-26480, People of the State of Michigan versus Zion Jumper. Detective Roberts, you've identified yourself for the record and you've been sworn. Please proceed with the facts established probable cause.
Yes, on the date on 12/28/2024 at 364 North Paddock in the city of Pontiac. He resides there, Mr. Jumper, with his mother. He became very argumentative with his mom. She locked him out of the house, and he proceeded to shatter the windows of the location. He entered the location. His mom and sister had to hold him down to keep him from assaulting them. Deputies arrived on scene, and he was taken into custody.
All right, the court finds alleged crimes were committed. There's probable cause to believe that the defendant committed them. My inclination, having reviewed the file, would be to set some sort of high personal bond in this. Do you have any thoughts with respect to bond?
Okay.
You don't think that would be unreasonable?
No.
Okay, great. All right, we are all squared away. So I guess once Miller calls, I'll do his three swear twos, then we'll be out to the jail. Thanks for calling in. Have a happy New Year.
What was your last name?
Bosnick, Bosnic.
Bosnic?
Correct.
All right, sir. You have a great day. Happy New Year.
Mike Bosnick or Michael Bosnick.
Okay. Thank you, sir.
All right, take care. Have a nice day.
Yep.
Yeah, I really love doing this type of docket where it has the swear tos from the officers, and then we get to see the actual cases. Normally, when I run these, I'll hopscotch them, where I will, edit it to where I put them one right after the other so that there's no delay in between and we can follow it fluidly. Unfortunately, I did not have time to do that with this docket. So we're left with trying to remember what the judge said 3 minutes prior.
Good morning. Can you hear me?
I can. Good morning.
Hey, good. Nice to see you. Good morning. All right. So you've got 3 swear twos, Serbaugh, Minch, and Johnson Jr.
Yes.
Which one would you like to do first?
I got Johnson Jr. sitting in front of me.
All righty. Let's call case number 24-26485, people of the state of Michigan versus Robert Edward Johnson Jr. Detective, please state your name for the record.
Detective Michael Miller, Oakland County Sheriff's Office.
All right. Do you solemnly swear affirm the testimony you're about to give us to the best of your knowledge, information, and belief?
I do.
Please proceed with the facts established probable cause.
On December 28, 2024, Robert Johnson Jr. was involved in a property damage accident at Baldwin and Mount Calm in the city of Pontiac. The other driver involved was Yancey Trinidad. Once they exited the vehicles, Johnson began yelling at Yancey and then reached out and aggressively grabbed Yancey by the hand, knocking her phone from her hand. Yancey felt unsafe, so she drove home to 169 East Wilson, also in the city of Pontiac. Johnson followed her to that location and continued to confront her about the accident. Yancey's father, who was Brian Ulrich, intervened to stop Johnson from pursuing Yancey, and Johnson punched Brian one time in the face with a closed fist.
All right, the court finds alleged crimes were committed as probable cause to believe that the defendant committed them. There will not be any interim bond. My thoughts on this are some sort of personal bond. What are your thoughts with respect to bond, Detective?
Yeah, I'm fine with that.
Okay, very well, thank you. What would you like to do next, Serbaugh or Mitch?
I got Serbaugh sitting here.
All righty, calling prosecutor order number 24-26488, people of the state of Michigan versus Romeo Ace Serbaugh, where it is alleged that on or about December 29, 2024, in the city of Pontiac, the accused committed the offense of domestic violence. Detective, you've identified yourself for the record and you've been sworn. Please proceed with the facts established probable cause.
On December 29, 2024, Romeo Serbaugh and Amaya Browder were involved in a verbal dispute at 163 Ridgemont in the city of Pontiac. During the argument, Serbaugh grabbed Amaya by the head and put her in a headlock and then threw her down. Amaya sustained minor abrasions as a result of the incident. Serbaugh and Amaya live together at that location and have a dating relationship.
All right, the court finds alleged crime was committed as probable cause to believe that the defendant committed it. What are your thoughts with respect to bond in this matter?
I
do know here he's currently on felony probation out of the 6th Circuit Court.
Yes.
So you think some sort of a cash bond with a 10% provision, personal, what do you think would be appropriate?
I think a 10% cash provision would be appropriate, Your Honor.
Okay, very well. All right, thank you very much for that. And are we ready to move on to the Minch case?
Yes.
All right, calling case number 24-26476, people of the state of Michigan versus Elise Phillips Minch, where it is alleged that on or about December 28th of this year, the accused did commit misdemeanor assault. Detective, you've identified yourself for the record and you've been sworn. Please proceed with the facts established probable cause.
I really hope this is the last swear to. The judge run out of room on his desk already.
On December 28, 2024, Elise Minch and Daniel Lewis were involved in a verbal dispute at 4 Clark in the city of Pontiac. 4 Clark is an apartment building, and Minch and Lewis do not live in the same apartment. During this dispute, which did happen inside of the complex, Minch struck Lewis in the arm with a broom handle.
Okay. The court finds alleged crime was committed as probable cause to believe that the defendant committed it. There will not be any interim bond. Having reviewed the file, my inclination on this one is personal bond. Do you have any thoughts with respect to bond?
I mean, there is going to be some sort of an issue between them because they do live in the same building. It's an apartment, but it's like a boarding house type apartment. So they're going to have frequent.
I was considering an order that she just not return to this victim's apartment. That she can be in the at the address, but not at his apartment.
Okay.
So, all right, do you think a personal bond would be reasonable?
Yeah, I think that's fine.
Okay, all right, great. Thank you very much, Detective. Great to see you. A happy new year.
Same to you.
I see you down the road.
All
right. Good morning. Please state your name.
Lisa Brooks.
Okay. Calling case number 24-7823, people of the state of Michigan versus Lisa Brooks. You've identified yourself. Counsel, please put your appearance on the record. I'd like to proceed.
Thank you, Your Honor. Rebecca Roberts, on behalf of Lisa Brooks, Your Honor, we waive formal reading. My client would stand mute, and she is requesting appointed counsel.
And based on your conversation with her, does she appear to qualify?
Yes, Your Honor.
All right. I'll enter a not guilty plea for purposes of arraignment. I'll advise Ms. Brooks she's presumed innocent until proven guilty beyond a reasonable doubt. She's got the right to try this matter by judge and jury. She's got the right to remain silent. That silence cannot be used against her, and she's got the right to be represented by an attorney. If she cannot afford one, the court would appoint one. The court is likely to do so in this matter. Ms. Roberts, with respect to bond, my inclination is to set a personal bond with standard conditions. Do you have any additional comment?
No, Your Honor, we would ask for a personal bond, but she hasn't been in trouble for over 30 years, so.
All right, the bond will be $5,000 personal with the condition that Ms. Brooks not have any contact with Bobby Judge, not return to 201 Reitman in Rochester, not harass or intimidate any witness. She must appear for any court proceeding, not leave the state without permission of the court. Notify the court in writing of any change of address or telephone number, not possess firearms, other dangerous weapons, refrain from using any alcohol, marijuana, illegal drugs, or non-prescribed medications, no new criminal offenses, and she'll be supervised by the court's bond compliance program, which she must contact within 24 hours of her release. Do you understand all that, Ms. Brooks?
Yeah, but I live at 201 Reitman Court. Can I go to my house?
Where does Ms. Judge live?
She lives, well, she technically lives in a hotel with her boyfriend, but she's not staying at our house right now.
All right, I'll modify that condition, but you still can't have any contact with Bobby Judge. So if Bobby Judge is at your place, he cannot be at your place, okay?
Okay.
All right, you're all set, Ms. Brooks. Good luck to you.
Okay, thank you.
It's a personal bond, so you don't have to post any money to be released.
Oh, okay, thank you.
There's a lot of judges that would have said, well, now you go find the hotel, regardless of the fact that it's your place. Luckily, hopefully, they don't actually live with her. I don't know if she was trying to do a good deed by letting them stay or what happened, but yeah, at least she gets to go home.
You can step out. You're all set.
Okay, thank you so much.
Yep. Happy New Year.
Happy New Year. Thank you. You too.
Good morning. Please state your name.
Tamara Ray Wolf.
All right. Calling case numbers 24-133019-940, 16-3208, 17-3506. All our three cases involve Tamara Ray Wolf. Ms. Wolf, you have a, let's see, case 1330 is the state of Michigan versus Wolf. Case 9 ending in 940 is White Lake versus Wolf. Case ending in 3208 is White Lake versus Wolf, and case 173506 is state of Michigan versus Wolf. You've identified yourself. Counsel, please put your appearance on the record. I'd like to proceed.
Rebecca Roberts Spring on behalf of Ms. Wolf on all four cases, Your Honor. We'd ask that you recall the warrants and set new dates.
All right, we will do that now for these cases. All four of these cases are all in bench warrant status, and the defendant has not appeared. Does your client request court-appointed attorney going forward, Ms.
Yes,
Roberts? Yeah, based on the information she's provided, I think that would be appropriate. With respect to all four cases, as these bonds were set by the judges, respective judges, and they were reasonable at the time, my inclination would be to continue them, but I'll listen to your argument.
Yes, Your Honor, my client has been through a rough several years. She tells me that she was, at one point, she had had a baby, and that's why she didn't appear. She was in rehab. Her husband passed away last year. She does start a new job on January 7th. She has absolutely no money because she hasn't been working. So she is asking for personal bonds, and she promises to take care of these matters.
All right, I do appreciate the argument. I do appreciate the promise. However, it appears Ms. Wolf has a history of failing to appear in court as ordered, which is why she has these 4 open cases dating back a number of years. So the court's going to continue the bonds in all of these and for all 4 cases, because the court needs to ensure her appearance. Case 3506, the bond is going to be $1,200, cash surety, no 10%. Case 163208, bond will be $250, cash surety. Case 19940, the bond will be $1,200. In case 241330, the bond will be $7,500, cash surety, no 10% on any of the cases. With all previous bond conditions continuing, you'll be notified of your next court dates. Ms. Wolf, you're all set. Good luck.
Thank you.
Hello, please state your name.
Elise Minch.
Calling case number 24-26476, people of the state of Michigan versus Minch. Ma'am, you've identified yourself. Counsel, please put your appearance on the record. I'd like to proceed.
Rebecca Roberts, on behalf of Ms. Minch, Your Honor, we waive formal reading. My client would stand mute. She is requesting court-appointed counsel.
And based on your conversations, whether does she appear to qualify?
Yes, she is not working.
All right. I'll enter not guilty plea for purposes of arraignment. I'll advise Ms. Minch she's presumed innocent until proven guilty beyond a reasonable doubt. She's got the right to try the matter by judge or jury. She's got the right to remain silent. That silence cannot be used against her. And she's got the right to be represented by an attorney. If she cannot afford an attorney, the court appoint one on her behalf. Do you understand all that, Ms. Minch?
Yes, sir.
All right. Counsel, with respect to bond, my inclination is to set a personal bond with standard conditions. Do you have an additional comment?
No, Your Honor, we would just ask for a personal bond. She hasn't had any trouble, and I think a personal bond is appropriate.
All right, the bond will be set at $5,000 personal, which means you're not going to have to post any money to be released, Ms. Minch. Conditions not to have any contact with Daniel Lewis, not to return to 4 Clark Street, not go to apartment number 2. You must not harass or intimidate any witness. You must appear for any court proceeding, not leave the state without permission of the court. Notify the court in writing if any change of address or telephone number, not possess firearms or other dangerous weapons, refrain from using any alcohol, marijuana, or illegal drugs, no new criminal offenses, and you will be supervised by pretrial services you must contact within 24 hours of your release. You're going to be given your next court date before you're released. So we're all set, Ms. Minch. Unless you have any questions, we're all set. Okay, push on the door. A deputy will be by to help. Good luck.
Thank you.
Usually people are happy to get personal bonds, Ms. Roberts.
I know. I have one who says he does not want a personal bond. I can't remember which one it was.
That lady said I might as well stay here. That was her comment to the deputy.
Well, I guess if you were just going to guess, your odds would be like 1 in 15 to see who that was going to be. Yeah, a couple of the people we're going to be speaking to later, I'm not sure whether they qualify for court appointments or not, so I've got those flagged. So I may have some additional questions for you.
Those that I wondered too.
Yeah, when I go back through and hopscotch them together for the replay crew minis and whatnot, I'm going to have to match them up by name since they're waiving the formal reading and not giving a whole lot of detail when they do the arraignment of the actual person. But I do want to put a few of these together with their swear to and their hearing. Probably that lady. She was one I think I'm gonna match the name and put the case together.
All right. Good morning, sir. Please state your name.
Robert Johnson, Edward Jr.
Alrighty. Calling case number 24-26485, people of the state of Michigan versus Robert Edward Johnson Jr. So you have identified yourself. Counsel, please put your appearance on the record. How would you like to proceed?
Yes, Your Honor. Rebecca Roberts Spring on behalf of Mr. Johnson. We waive formal reading. My client would stand mute, and he is requesting appointed counsel at this time.
Okay. Based on the information you provide, it looks like his take-home pay after taxes is $45,000. Without any bills, under list your monetary obligations and amounts, it states no. Does your client have any bills that he has to pay, Ms. Roberts, that you're aware of?
Yeah, yes, Your Honor. He told me he has, his rent is $1,400, his car payment is $407, his insurance is $170, his phone bill is $100, his utilities are $330.
Okay, thank you for clarifying. Yeah, thank you for clarifying that, what he put on the form. That's more instructive. It appears as though he would qualify, so he's going to be referred for court-appointed attorney services consideration. I will enter a not guilty plea for purposes of arraignment. I'll advise Mr. Johnson he's presumed innocent until proven guilty beyond a reasonable doubt. He's got the right to try his matters by judge or jury. He's got the right to remain silent. That sounds cannot be used against him. He's got the right to be represented by an attorney if he cannot afford one. The court will appoint one. The court's likely to do so here. Counsel, with respect to bond, my inclination is to set a personal bond with standard conditions. Do you have any additional comment?
No, Your Honor. We'd ask for a personal bond.
All right, bond will be $10,000 personal, with the conditions that Mr. Johnson Jr. not have any contact with Yancey Trinidad or Brian Ulrich, not return to 169 East Wilson and Pontiac, must not harass or intimidate any witness. He must appear for any court proceeding, not leave the state without permission of the court, notify the court in writing of any change of address or phone number, not possess firearms, other dangerous weapons, refrain from using any alcohol, marijuana, or legal drugs, no new criminal offenses, and he must contact pretrial services within 24 hours of his release. He'll be given their contact information. All right, Mr. Johnson, if you don't have any other questions, you're all set. If you push on the door, a deputy will be by to help. You got a personal bond, so you don't have to post anything to be released.
Thank you, sir.
All right.
Good luck, sir.
Yeah, thank you too.
Good morning. Please state your name.
Romeo A. Serbaugh.
All right. Calling case number 24-26488, people of the state of Michigan versus Romeo Ace Serbaugh. So you've identified yourself for the record. Counsel, please put your appearance on the record. How would you like to proceed?
Rebecca Roberts Spring on behalf of Mr. Serbaugh. Your Honor, we waive formal reading. My client would stand mute, and he is requesting appointed counsel.
All right. Based on your conversations with him, does he appear to qualify?
Yes, he makes $100 a week, Your Honor.
Okay. All right. All right, I'll enter not guilty plea for purposes of arraignment. I will advise Mr. Serbaugh, he's presumed innocent until proven guilty beyond a reasonable doubt. He's got the right to try the matter by judge or jury. He's got the right to remain silent if he decides to remain silent. That cannot be used against him. He's got the right to be represented by counsel. He cannot afford an attorney, the court will appoint one on his behalf. Do you understand all that, Mr. Serbaugh?
Yes, I do.
All right. Counsel, as to bond, the court's got some concerns regarding the fact that he does have a pending violation of probation matter out of Sixth Circuit Court, and it looks like there's a prior offense for resisting police. So the court's got some concerns, but I'll listen to your argument with respect to that.
Yes, Your Honor. My client tells me that this incident was a misunderstanding. He also tells me that the Sixth Circuit case is going along fine and he doesn't understand why there's violation of probation pending. I would ask for a low cash bond, Your Honor. Obviously, he has very little funds and he needs to get out and get to work and take care of his children, who he has custody of, one of them, I believe. So I would ask for a low cash bond, Your Honor. I advised him that he's not eligible for a personal bond.
Yeah, like I indicated, the court's got some concerns. It appears as though he was supervised by Sixth Circuit Court at the time that he accrued these charges. Those offenses that I think he had pled to, perhaps under HIDA, were assaulting or resisting the police, 2 counts of that, and also another assault case. He has another domestic assault that's suppressed from 2023. So there's a history of violence the court's concerned with. So in order to protect the public and ensure defendant's appearance, court's going to set a bond amount of 25,000 cash surety or 10%. And the conditions are Mr. Serba cannot have any indirect contact with the Maya Browder, not return to 163 Ridgemont in Pontiac. He must not harass or intimidate any witness, must appear for any court proceeding, not leave the state without permission of the court, notify the court in writing of any change of address or telephone number, not possess firearms, other dangerous weapons, refrain from using any alcohol, marijuana, or illegal drugs. He'll be supervised by pretrial services, who he must contact within 24 hours of his release and no new criminal offenses. He'll be notified of his next court date. All right, Mr. Serba, you're all set. Good luck to you.
Okay.
Good luck.
Does that mean I get a bond?
It's 25,000, 10%.
What's the 10%? I don't really know how it all works. I'm just trying to ask.
2,500, sir. Sir, you're all set. Thank you.
Oh, all right, thank you.
Good morning, sir. Please state your name.
Andre Cheatum.
All right, calling case number 24-26464, People of the State of Michigan versus Mr. Cheatum. Sir, you're Andre Durrell Cheatum. You've identified yourself. Counsel, please put your appearance on the record. I'd like to proceed.
Rebecca Roberts, appearing on behalf of Mr. Cheatum. We waive formal reading. My client would stand mute, and he is requesting court-appointed counsel.
All right, based on your conversations with him, does he appear to qualify? He's indicated in his form that he owns some sort of business.
He is self-employed, Your Honor, so therefore he is not working because he's incarcerated and he has no income.
All right, very well, then I think that'd be appropriate. I'll enter not guilty plea for purposes of arraignment. I'll indicate to Mr. Cheatum he's presumed innocent until proven guilty beyond a reasonable doubt. He has the right to a preliminary examination in 21 days where the prosecutor must establish that these crimes were committed and there's probable cause to believe he committed them. He has the right to try these matters by judge or jury. He's got the right to remain silent. That silence cannot be used against him. He's got the right to be represented by an attorney. If he cannot afford one, the court will appoint one. The court is likely to do so in this matter. Do you understand all that, Mr. Cheatum?
Yes, sir.
All right. Ms. Roberts, in light of the charges, I've got extremely grave concerns, but I'll listen to your argument with respect to bond.
Yes, Your Honor. My client vehemently denies the commission of these offenses. He indicates that this person is a problem in his life, his mother's life, his entire family's life. He also tells me he is the sole breadwinner for an extended family, his children, his mother, other people. So he really needs to get out and get back to work. I would ask for a bond, Your Honor. I understand these are serious offenses, but the way he explained it to me, it sounds like he has a very good defense and that there is a chance that this matter could be dismissed. So I would ask for possibly 10,000, 10% bond. He tells me he will be, he knows he has a history where he didn't take care of matters, but he says he's a changed person now. He's responsible. He's a parent. He's being a devoted son. And so he has changed his life around and that he will be attending court because he wants to clear his name because he feels he is innocent.
All right, I do appreciate the argument in reviewing the current charges against Mr. Cheatum. Count 1 is a capital life felony, punishable by life in prison or any number of years. Count number 2 is a firearm related felony. Count 3 is a firearm related felony. Count 4 is a firearm related felony. And count 5 is a firearm related felony. So in order to protect the public, I'm going to deny bond at this time with the order that he not have any contact with Jemiah Moore, and he will be supervised by pretrial services. His next court date is a probable cause conference on January 9th at 1:30 p.m. His exam is January 16th at 9 a.m. Both of those in front of the district court in Pontiac, and he would have an opportunity at that time to modify my bond order if the court sees fit, or he could always try to get in there prior thereto with some sort of argument. So you're all set, Mr. Cheatum. Good luck to you.
Okay, so I'm not understanding what happened.
Pardon me?
No, I'm not understanding what happened.
Okay, yeah, your bond is denied. Your next court date is a probable cause conference on January 9th, and you're going to be assigned an attorney, so you'll likely be hearing an attorney.
So you're sitting there until January 9th. That's what's going on.
From an attorney.
Okay.
Hello, please state your name.
Tushar Sharma.
All right, thank you for that information. Calling case number 24-7829, people of the state of Michigan versus Tushar Sharma. You've identified yourself for the record. Counsel, please put your appearance on the record. I'd like to proceed.
Yes, thank you, Your Honor. Rebecca Roberts appearing on behalf of Mr. Sharma. We waive formal reading. My client would stand mute, and he tells me he will be hiring his own attorney.
Very well. I'll enter not guilty plea for purposes of arraignment. I'll indicate to Mr. Sharma he's presumed innocent until proven guilty beyond a reasonable doubt. He's got the right to try the matter by judge or jury. He's got the right to remain silent that sounds cannot be used against him. He's got the right to be represented by an attorney. If he cannot afford an attorney, the court would appoint one on his behalf. However, he's going to retain counsel. With respect to bond, my inclination is to set a personal bond with the standard conditions. Do you have any additional comment with that, Ms. Roberts?
No, Your Honor, I'd ask you for a personal bond.
All right, bond's going to be $5,000 personal with the conditions that Mr. Sharma not have any contact with Vijeshwai Sharma, must not harass or intimidate any witness. He must appear for any court proceeding, not leave the state without permission of the court, notify the court in writing. If any change of address or telephone number, not possess firearms, other dangerous weapons, refrain from using any alcohol, marijuana, or illegal drugs. No new criminal offenses, and he'll be supervised by the court's bond compliance program. So you are all set, Mr. Sharma, unless you have any questions. If you push on the door, a deputy will be by to help.
Thank you, sir. I appreciate you.
Good luck.
Good morning, sir. Please state your name.
Shaibu Gopalan.
All right, thank you. Calling case number 24-7824, people of the state of Michigan versus Shaibu Gopalan. You've identified yourself for the record. Counsel, please put your appearance on the record. How would you like to proceed?
Rebecca Roberts appearing on behalf of Mr. Gopalan. Your Honor, we waive formal reading. My client would stand mute, and he is going to retain his own attorney.
Very well. I'll enter not guilty plea for purposes of arraignment. I'll advise Mr. Gopalan he is presumed innocent until proven guilty beyond a reasonable doubt. He's got the right to try these matters by judge or jury. He's got the right to remain silent that sounds cannot be used against him. He's got the right to be represented by an attorney if he cannot afford one. The court will appoint one for him. However, he's going to retain counsel in this matter. With respect to bond, my inclination is to set a personal bond with standard conditions. Do you have any additional comment?
No, Your Honor.
All right, bond is going to be $5,000 personal with the following conditions: that Mr. Gopalan is not to have any contact with Savitha Vidyadharan, that he's not to return to 3472 Summit Ridge Drive in Rochester Hills, that he must not harass or intimidate any witness, that he appear for any court proceeding, not leave the state without permission of the court, notify the court in writing. If any change of address or telephone number, not possess firearms, other dangerous weapons, refrain from using any alcohol, marijuana, or illegal drugs, no new criminal offenses, and he must contact the court's bond compliance program within 24 hours. And he may return to that address one time with police if he needs to retrieve his personal items. So if you understand all that, Mr. Gopalan, and you don't have any questions, you're all set. If you push on the door, a deputy will be by to help.
Your Honor, I just have one. Would he be able to contact her to arrange parenting time?
No, I mean, he'd have to do it through a third party. He'd have to do it. He'd have to figure out some other way to do it.
Okay. So you can get someone else to contact your wife to see your children, okay?
Okay, can I talk to?
I think, Mr. Gopalan, you're all set.
You can talk to your children, but not your wife.
Okay, sure. Thank you.
Okay.
Good luck.
Thank you. Thank you. Thank you, sir.
This one I did not have a warrants on, so.
What's this?
I
don't know.
I'm assuming it's gonna be easy.
Oh, it's a no by case. Did Did you see the pretrial services report on it?
Yeah.
Okay. Do you need to review that paperwork? Should I have the clerks get you that paperwork?
No, we'll just have, you can just read them on the record.
All right.
Morning,
Hello, sir. Please state your name.
Hans Adam Geis.
All right. Calling case number 24-4057, State of Michigan versus Geis. You've identified yourself for the record, counsel. Please put your appearance on the record. How would you like to proceed?
Rebecca Roberts, appearing on behalf of Mr. Geis. Your Honor, I did not get the warrant, so we're asking that you read those into the record.
Okay, very well. All right, Mr. Geis, the allegation is that you, on or about November 5th, 2024, in the Township of Lyon, did commit the offense of larceny by stealing equipment, including but not limited to a laptop, computer, AirPods, keys, and impact and generator cables that belong to Alta Equipment. The value of the property taken was $1,000 or more, but less than $20,000. It's a third subsequent offense, and that you have a previous conviction for larceny over $20,000 in the 44th District Court from September 5th, 2002, and that it looks like on January 18, 2011, you had a previous conviction for larceny over $20,000 in the 22nd District Court. So since it's the third offense, or third subsequent offense, it's a felony with a maximum possible penalty of 10 years in prison and or $15,000 or 3 times the value of the property stolen, whichever is greater. And that there is also a count of larceny, 1,000 or more, but less than 20,000, third subsequent offense. And that you did on or about November 5th, 2024, did without breaking, enter a shop, which is a warehouse or an office located at 58,000 Grand River Avenue with intent to commit the crime of larceny therein. That's a 5-year felony with a maximum possible fine of $2,500. Looks like there's that's the count 2 of breaking and entry without breaking with intent. So I'll enter a not guilty plea for purposes of arraignment on your behalf. I'll indicate to you that you're presumed innocent until proven guilty beyond a reasonable doubt. You've got the right to a preliminary examination within 21 days where the prosecutor must establish these crimes were committed. There's probable cause that you committed them. You've got the right to try these matters by judge or jury. You've got the right to remain silent. That silence cannot be used against you. You've got the right to be represented by an attorney if you cannot afford counsel. Court appointment for you. Do you understand all that?
Yes, sir.
All right, counsel, does Mr. Geis wish to avail himself of court-appointed attorney? Is he going to retain counsel?
He needs court-appointed, Your Honor. He's been in jail 40 days and not been working, so.
All right, very well, then I think that would be appropriate. What do you have to indicate with respect to bond?
Your Honor, as I indicated, he is in jail. We're asking for a low cash bond.
Okay, the court does note Mr. Geis's past history. So to ensure his appearance and public safety, court's going to set bond amount of $25,000, cash 30 or 10%, with the conditions he not return to 58,000 Grand River or Alta Equipment, that he appear for any court proceeding, not leave the state without permission of the court, notify the court in writing of any change of address or telephone number, not possess firearms or other dangerous weapons, refrain from using any alcohol, marijuana, or legal drugs. The under criminal offense is he'll be supervised by pretrial services, who he must contact within 24 hours of his release. His next court date is a probable cause conference set for January 13th at 9 a.m. His exam is set for January 21st at 9 a.m. Both of those at the Novi District Court. All right, Mr. Geis, you're all set. If you push on the door, deputy will be by to help.
Thank you, Your Honor.
All right, good luck.
Let's see it slide into the wall.
Good morning, sir. Please state your name.
Ernest Carlton Lovelady Jr.
All right, calling case number 24-4056, People State of Michigan versus Ernest Carlton Lovelady. You've stated your name for the record, counsel. Please put your appearance on the record. How would you like to proceed?
Thank you, Your Honor. Rebecca Roberts, Spring on behalf of Mr. Lovelady. Your Honor, we waive formal reading. My client stands abused and he is going to need appointed counsel.
All right, not guilty plea for purposes of arraignment. I'll advise the defendant he's presumed innocent until proven guilty beyond a reasonable doubt. He's got the right to a preliminary examination in 21 days, where the prosecutor must establish that this crime was committed and there's probable cause to believe he committed it. He's got the right to try this matter by judge or jury. He has a right to remain silent. That silence cannot be used against him. He's got the right to be represented by an attorney. If he cannot afford an attorney, the court will appoint one on his behalf. And based on the information provided, the court is likely to do so. Counsel, you may address bond.
Yes, Your Honor. My client tells me that he lost his job 3 weeks ago. He's kind of been on a downward slope since then. He was working in heating and cooling. But since then, he's been homeless. I don't know what happened to his car, but someone took his car, so he was living in his car. He's homeless.
Auntie M, does that mean this guy is HVAC?
We're asking for a low cash bond, Your Honor.
All right, the court does note the amount involved here was rather large. The court does note that the potential possible penalty, this is a serious felony, 14-year felony. So the court's got some concerns regarding public safety. So the court feels a cash 10% bond is appropriate, but maybe nothing incredibly onerous. So the court's going to set bond in this matter at $7,500, cash 30 or 10%, with the condition that Mr. Lovelady not have any contact with Community Choice Credit Union, that he appear for any court proceeding, not leave the state without permission of the court, notify the court in writing of any change of address or telephone number, not possess firearms, other dangerous weapons, refrain from using any alcohol, marijuana, or illegal drugs, no criminal offenses, and he'll be supervised by pretrial services. So he must contact within 24 hours of his release. Do you understand all that, Mr. Lovelady?
I do, it's just I don't have anywhere to go. Can I just stay in jail?
Yes, you don't have to post your bond.
Okay.
Okay.
Yeah, that's always an option. All right, you're all set, Mr. Lovelady. If you push on the door, deputy will be by to help. Thank you.
Thank you. All set.
That was the one.
Okay. Yeah, I'm happy I was able to accommodate him.
Yes. Thank you.
Because it's not that big of a bond, but I guess it's up to him if he decides he'd rather not post.
That's right.
That's always an option.
The jail's better than outside, so.
Yeah. Hi there. Please state your name.
It's certainly warmer.
Gavin Carroll McKinley.
All right, calling case number 24-26459, People of the State of Michigan versus Gavin Carroll McKinley. You've identified yourself. Counsel, please put your appearance on the record. How'd you like to proceed?
Rebecca Roberts Spring on behalf of Mr. McKinley. Your Honor, waive formal reading. My client would stand mute, and he is requesting appointed counsel.
Okay, based on your conversation, do you feel he qualifies?
Yes, Your Honor.
All right, I'll enter a not guilty plea for purposes of arraignment. I'll advise Mr. McKinley he's presumed innocent until proven guilty beyond a reasonable doubt. He has a right to a preliminary examination within 21 days where the prosecutor must establish that this crime was committed and there's probable cause to believe he committed them. He's got the right to try his matters by judge or jury. He's got the right to remain silent. That silence cannot be used against him. He's got the right to be represented by an attorney. If he cannot afford an attorney, court appoint one on his behalf. Do you understand all that, Mr. McKinley?
Yes, Your Honor.
All right, counsel, you may address bond.
Yes, Sharon. My client is very confused because he says this is his house and he doesn't understand how he can be charged with attempted home invasion to his own house. So in light of that, Your Honor, we're asking for a personal bond. My client has a minor criminal history. This alleged victim is his ex-girlfriend. He tells me she is not supposed to be at this home. This is his home. So again, we're asking for, it sounds like he has these cases, and we're asking for a personal bond in this matter.
All right, looks like there's a history of domestic violence. There are serious matters. The court's got some concerns regarding public safety. So in order to protect the public, the court's going to set bond the amount of $15,000, cash 30 or 10%, with the conditions that Mr. McKinley not have any contact with Cassie Roach or return to 738 3rd Street in Pontiac. If he needs to return one time with police to retrieve personal items, he may do so. Must not threaten or harass any witness. He must appear for any court proceeding, not leave the state without permission of the court, notify the court in writing. If any change of address or telephone number, not possess firearms, other dangerous weapons, not use any alcohol, marijuana, or illegal drugs, no criminal offenses. He'll be supervised by pretrial services who he must contact within 24 hours of his release, and he'll be required to be fitted with a GPS tether prior release, which would allow Mr. McKinley only to go to work, medical appointments, and court dates. His probable cause conference is set for January 9th at 1:30 p.m. His exam is set for January 16th at 9 a.m. Both of those at the Pontiac District Court. That's the order of the court. Mr. McKinley, you're all set. If you want to push on the door, deputy will be by the help. Good luck. Good afternoon, sir. Please state your name.
Zion Jumper.
All righty. Calling case number 24-26480, People of the State of Michigan versus Zion Jumper. You've identified yourself for the record. Counsel, please put your appearance on the record. I'd like to proceed.
Rebecca Roberts, appearing on behalf of Mr. Jumper. Your Honor, we waive formal reading. My client would stand mute, and he is requesting court-appointed counsel.
All right, I'll enter a not guilty plea for purposes of arraignment. Does your client qualify for court-appointed attorney services based on your conversations with them?
I believe so, yes, Your Honor.
All right, Mr. Jumper, you've got the right, you're presumed innocent until proven guilty beyond a reasonable doubt. You've got the right to try this matter by judge or jury. You've got the right to remain silent. That sounds cannot be used against you. You've got the right to be represented by an attorney if you cannot afford one. The court will appoint one. The court likely will do so in this matter. With respect to bond counsel, my inclination is to set a personal bond with standard conditions, but I'll listen to your argument.
You would ask for a personal bond, Your Honor. Thank you.
All right, so bond in this matter will be $10,000 personal, so you're not going to have to post any money to be released, sir. The conditions, you're not to have direct or indirect contact with Roxanne Hernandez. You're not to return to 364 Paddock Street in Pontiac. You may return one time with a police escort to retrieve your personal items. You must not harass or intimidate any witness. You must appear for any court proceeding, not leave the state without permission of the court. Notify the court in writing of any change of address or telephone number. Not possess firearms, other dangerous weapons, refrain from using any alcohol, marijuana, or illegal drugs. No criminal offenses, and you'll be supervised by pretrial services who you must contact within 24 hours of your release. You'll be given their contact information. So if you understand all that, Mr. Jumper, you don't have any questions, you're all set. If you push on the door, a deputy will be by to help.
Can I ask a question?
Sure.
So you saying I'm getting a personal bond?
Yes.
Okay, I was just making sure because I was kind of talking kind of like a little fast, so I had to kind of.
I talked fast. You got that right, Mr. Jumper. All right. Yeah, you're all set. It's a personal bond. You don't have to post any money to be released. Okay.
Okay, I appreciate both of you guys.
Okay. Good luck to you, Mr. Jumper. Have a happy New Year. Stay out of trouble. Good luck to you. We'll see you.
Same to you guys.
All right. So who's next?
Broom.
Okay.
Yeah, we'll talk to them about it.
All right, thank you.
You're welcome.
Good afternoon, sir. Please state your name.
John Matthew Broom.
All righty. Calling case number 24-26472, People of the State of Michigan versus John Matthew Broom. Sir, you've identified yourself. Counsel, please put your appearance on the record. How'd you like to proceed?
Rebecca Roberts, appearing on behalf of Mr. Broom. Your Honor, we waive formal reading. My client would stand mute, and he is requesting appointed counsel.
Based on your conversation with him, does he appear to qualify?
Yes, Your Honor, he is laid off and earning $105 a week.
All right, I'll enter a not guilty plea for purposes of arraignment. I'll advise Mr. Broom he's presumed innocent until proven guilty beyond a reasonable doubt. He has a right to a preliminary examination within 21 days where the prosecutor must establish that this crime was committed and there's probable cause to believe he committed it. He's got the right to try the matter by judge or jury. He's got the right to remain silent. That silence cannot be used against them. He's got the right to be represented by an attorney. If he cannot afford one, the court would appoint one. The court is likely to do so in this matter. With regard to bond, counsel, my inclination is to set a personal bond with some testing. I'll listen to any argument you may have.
Your Honor, we would ask for a personal bond. He is never had a felony before. He has a few minor misdemeanor offenses in his past, so we're asking for a personal bond.
All right, court will set bond in the amount of $15,000 personal with the following conditions. Mr. Broom must appear for any court proceeding, not leave the state without permission of the court. Immediately notify the court in writing of any change of address or telephone number, not possess firearms, other dangerous weapons, refrain from using any alcohol, marijuana, or illegal drugs. We'll test once a week randomly for alcohol and drugs through pretrial services. You'll be supervising him. He must contact them within 24 hours of his release. He'll be given their contact information, no new criminal offenses. His next court date is a probable cause conference set for January 9th at 1:30 p.m. His exam is set for January 16th at 9 a.m., both those at the Pontiac District Court. So if you have no other questions, Mr. Broom, you're all set. Good luck to you.
Thank you, sir.
Right. All right, Ms. Roberts, who's next?
Yeah, Eric Graham. And they told me they did not get a call for Cantu, so that one's not going.
Oh, I've got the Cantu file.
I know, I have it too, but.
What good is the Cantu file if you don't have the Cantu person? Cantu can't go.
So we can't to him?
I guess not.
Can't do Cantu.
Sorry about the dad joke, Ms. Roberts.
I'm used to it, believe me.
All right, sir, are you Mr. Eric Darmian Graham? Is that yes?
Yes, sir.
Okay, thank you. Calling case number 2426479, People State of Michigan versus Eric Graham. You've identified yourself for the record. Counsel, please put your appearance on the record. How'd you like to proceed?
Rebecca Roberts, bring on behalf of Eric Graham, Your Honor. We waive formal reading. My client would stand mute, and he is requesting court-appointed counsel.
All right. I'll enter a not guilty plea for purposes of arraignment. Based on your conversations with Mr. Graham, does he qualify for court-appointed attorney services?
Yes, Your Honor, he's not working.
All right. I'll enter I entered a not guilty plea for purposes of arraignment. I will advise Mr. Graham, he's presumed innocent until proven guilty beyond a reasonable doubt. He's got the right to try his matters by a judge or jury. He's got the right to remain silent. That silence cannot be used against him. He's got the right to be represented by an attorney. If he cannot afford an attorney, the court would appoint one on his behalf. And based on the statement of facts, of course, likely to do so. My inclination, counsel, is to allow a personal bond with standard conditions. Do you have any additional comment?
Oh, no, Your Honor, we'd ask for personal bond.
All right, bond will be set at $10,000 personal with the following conditions: that Mr. Graham not have any contact with Titania or Christine Bonner, not return to 595 Going Street in Pontiac. He may return one time with police to retrieve his personal items. He must not harass or intimidate any witness. He must appear for any court proceeding, not leave the state without permission of the court, immediately notify the court in writing. May change of address or phone number, not possess firearms, other dangerous weapons, refrain from using any alcohol, marijuana, or illegal drugs. He'll be supervised by pretrial services who he must contact within 24 hours of his release and not commit any more criminal offenses. Do you understand all that, Mr. Graham?
Yes.
All right, you'll be notified of your next court date. You are all set. If you push on the door, a deputy will be by to help. Thank you. All right, Ms. Roberts, I guess we'll take a break for now. I'm going to look into that Cantu file.
Sounds good.
All right, thank you. You've been a huge help. Thank you today.
No problem.
So Mr. Cantu down here.
Oh, you do have them. Okay. Yes. All right, I'll talk to him for a minute and then. Good morning, Mr. Cantu. My name is Rebecca Roberts. I'm your attorney for your arraignment.
Good morning.
I have you down. You have a bench warrant for drive while license suspended. Apparently you didn't appear. That was in 2020.
Hold on, Rebecca. Hold on. You're live on stream. We got to get you off.
Oh, okay. They do have them. We weren't sure.
Yeah, no problem. 1 second.
Hey, Ms. Roberts, sorry about that. I'm going to put you guys in a breakout room.
All right, we're set.
All right, thank you.
Uh-huh.
And then after Mr. Cantu, I think we're pretty much done with any more files. We've set a land speed record today.
Oh, okay.
Hello, this is case number, sir, are you Mr. Raphael Cantu?
Yes, yes, sir.
All right, this is case 17-8496, people of the City of Auburn Hills versus Raphael Cantu. This is a bench warrant matter. Has already been arraigned. Counsel, please put your appearance on the record. I'd like to proceed.
Thank you, Your Honor. Rebecca Roberts, appearing on behalf of Mr. Cantu. Your Honor, we'd ask that the bench warrant be set aside.
All right, we'll do that. Does your client desire to use a court-appointed attorney going forward?
Yes.
And based on your conversation with him, does he appear to qualify?
Yeah, sure.
Okay, then I think that'd be appropriate. With respect to bond in this matter, it looks like the judge set it at $12.92, no 10%. So what do you have to indicate with respect to bond?
Your Honor, we would ask for a 10% provision. My client says he has $200 on him. He can get the balance of that money as soon as he picks up his check, which is he was on his way to pick up his check when he got arrested, and no one else can get his check or cash his check for him. So he's telling me that he would be able to pay the entire matter off, put it behind him, and then take care of this. So we're asking just for a 10% provision on that so that he can do that.
All right, I appreciate the argument. This matter has been open since 2017. Mr. Cantu could have come in at any time to try to resolve this or deal with this, but apparently he's decided not to. So I think the bond, to ensure his appearance, I think the bond is set by Judge Assadorian is reasonable. So it'll be $1,292 cashier, no 10% without previous conditions to continue. All right, Mr. Cantu, you'll be notified of your next court date. You're all set. Good luck to you.
Thank you.
Okay, thank you. Thank you, Ms. Roberts.
Thank you. So do we need to stay till 1 or are we done or?
Yeah, we'll need to stay till 1.
Okay.
All right.
Thank you.
Yeah, the whole docket was like 4.5 hours long, I think, and I edited it all down. I know there were some parts in it that weren't spectacularly interesting, but you know, that's what I gotta go through sometimes for 12 to more hours a day to find the cases that I do find. So I figured I would just take you guys along on the trip with me this time. But oh, this has been a wonderful start to the new year. What a blessing. Hitting 4K at 12:56 p.m. the night, or I mean 11:56 p.m. the night before New Year's. 4 minutes to spare to get to 4K. That is just amazing. Thank you guys for coming out. I am so doggone tired. It's 7, there's 7 minutes until it changes over to 3 hours. I can't go. I have to stay here for 7 minutes. I'm gonna do it. I might fall asleep along the way, but I'm gonna do it. All right. Give me a minute. I'm gonna peruse the interwebs. Ooh. I don't know if this is gonna be any good, but this was on 13 hours ago, so we're going to check it out.
Okay, Mr. Klein, you're here on 2022 CR 353, State of Kansas first, Curtis Edward Klein. You're here today on a bench warrant appearance. Looks like you failed to appear for your pretrial conference, and a warrant was issued for your arrest. Cassie Ziegler is your attorney. Have you had any contact with Ms. Ziegler?
No.
Okay. Well, get in contact with Ms. Ziegler. She'll let you know They'll get this scheduled for a hearing to revoke your bond and also get this set for your pretrial conference. Okay?
Yes, Your Honor.
Any questions?
No, Your Honor.
All right, thank you.
Mr. Bush, you may see if you can find a
I want to hear the judge's fact of the day. He always does one.
Say your name.
What's your name?
Daniel Joseph Bush.
All right, Mr. Bush, you're here today on an unfiled case. It's like you were arrested on probable cause, could be charged with criminal threat. I'm here today to set your bond. Mr. Cunningham.
Your Honor, in reviewing the affidavit in this matter, although there could be probable cause for a criminal threat, I think that an OR bond is probably appropriate under these circumstances. I believe Mr. Bush is probably in services with High Plains, and it's probably important that he's able to resume those services.
Okay. Mr. Bush, I'm going to release you on a known recognizance bond today, which means you won't be posting any bond. No possession or consumption of alcohol or illicit drugs, no violation of any laws, and continue your services with High Plains Mental Health.
Your Honor, we might keep a no contact in place between him and Lauren Klaus, if there's a way for him to receive services through someone else from High Plains.
I was wondering the same thing, Mr. Cunningham. I don't want to put it in there if that's the only.
Right. I don't want to not advocate for it because I've not had the opportunity to speak to Ms. Klaus, Your Honor. So I understand the court's position, though, regardless of how the court rules.
Mr. Bush, is Ms. Klaus the only person you have contact with? I mean, she does, comes out to your apartment.
No, I also see Alyssa, Eric, and Tara, and Lauren Klaus. All High Plains mental health workers. ALT treatment team, Your Honor.
I'm not going to put a no contact order in just because I don't know the circumstances. If it was Judge Boone here, he would know the circumstances. I don't know those circumstances.
Yes, Your Honor.
Okay, you can be released. That's all I have for you.
Okay, thank you, Your Honor.
Go back and pack up your things.
Okay.
He's a water. We have to relocate, Your Honor.
All right. Thank you.
Come on, Judge. Give us our history fact. You know you wanna. Oh, he's gonna wait till the end. He does it every time. I'll be surprised if he misses. On this day in 1973, such and such happened. Yeah, he's waiting to the end. The Ellis County deputy's got a little bit of a walk to go. I know. I'm disappointed at the moment. He's a good judge. I really like him.
Hello?
Are you Marcus Smith?
Yes, Your Honor. I'm Marcus.
Mr. Smith, you're here today on an unfiled case. You're arrested on a probable cause of, looks like you could be charged with aggravated domestic battery impeding the breathing of a family member or dating relation, criminal threat, endangerment of a child. I'm here today to set your bond, Mr. Cunningham.
Thank you, Your Honor. The aggravated domestic battery would be a level 7-person felony. The criminal threat is a level 9-person felony. And then the endangering of a child is a class A person misdemeanor. Your Honor, in reviewing Mr. Smith's history, the state notes that he's an anticipated B or A criminal history, all of those resulting from either domestic batteries or aggravated batteries or regular batteries that have aggregated. The state does have concerns about community safety. We are going to request the court set bond at $50,000 cash or commercial surety. And in the event he were to post that, Your Honor, we would still request he be supervised by court services.
This guy is definitely a danger to the community. He has serious control issues, it sounds like.
And then we would also ask for no contact orders between him and the minor with the initials PB, and then Haley Barnes, Your Honor. We do note in reviewing the domestic violence lethality assessment form, the victim in this did screen exceptionally high. So I did want to point that out to the court as well. So in summation, we're asking for $50,000 cash or commercial surety.
Mr. Smith, you've heard the request for bond and the amount of bond. Anything you would like to say about the amount of bond without discussing any factors in your case?
No, Your Honor, I just think, I do think that's a little high to post bond, but I mean, other than that, no, Your Honor.
Your bond is set at $50,000 cash or commercial surety. If you're able to bond out, no contact of any way, shape, or form with Haley Barnes or with a minor child with the initials of PB. Keep a current address on file with the county attorney's office. Maintain contact with your attorney. No possession or consumption of alcohol or illicit drugs while you're out on bond. You're subject to random blood, breath, and urinalysis testing. That can be done any time of the day or night by any law enforcement officer, corrections officer. Anytime you come back to this court, you could have a urinalysis test. If you're unable to bond out, the county attorney's office has until January 10th, 2025 to file formal charges. If you are out on bond, your next court appearance is March 4th, 2025 at 8:30 a.m. And then concerning supervision, if he's out on bond, haven't had this happen for a while, so Ms. Gall, steer me in the right direction here.
Your Honor, I'd have him fill out a bond application so we could verify residence, make sure that he has stable housing and somewhere other than living with the victim.
Okay. Well, and I'm not telling you he's getting out on an OR supervision bond. He's going to have to post bond, but you still want the paperwork filled out so you have all that other information prior.
That would be nice, Your Honor.
Okay. So I'll have a questionnaire over there for you, Mr. Smith. You can fill that out so they can get it back to the court service office to see if all those factors meet their requirements. Okay?
Yes, Your Honor.
All right. Thank you.
Thank you, Your Honor.
And I believe that takes care of our jail docket.
That's all I showed.
That's everybody, sir.
Okay, thank you.
Thank you.
Thank you, Your Honor.
Got a couple history lessons for you. One, I know none of you'll remember this, but in 2019 on this day, the World Health Organization learned of a viral pneumonia case in Wuhan, China, that later was determined to be COVID-19, and it ruined us for
ever
till today. And then, I know none of you know this because none of you are old enough, but Roberto Clemente, who played professional baseball for the Pittsburgh Pirates, was flying back to his home country and was killed in a plane crash. Was my hero at the time. So there you go. Have a great day. Have a happy new year.
Happy New Year.
He always does it. Every single day. I love it. All right, guys. 2025. We're here. It's off to a great start. Thank you so much for spending it with me. Yeah, 3 hours. I even surpassed it by 5 minutes. Oh my gosh. You're not that old, Patrick B. I thought you were a young buck, just like us. I love you, she's the maker. Happy New Year to you too. Did you hear Earl just said it too? Yep, he was talking to you. Be safe, be well, sleep sweet, and much love.